Fine, my lord. This method come immediately after vacation, my lord.
Are you entitled to Upenda's benefit?
My lord.
Are you entitled to Bhupenda's benefit?
My lord, I have also training, my lord, regularization of my
Regularization after Upenda is not possible. Anyway,
my lord.
take your chance. Mr. A. Gohai, Learned Counsel for the petitioner, prays that the matter be adjourned today and taken after the ensuing vacation to facilitate him to prepare the matter further and make his submissions. Post prayer is not objected to by the Learned Counsel for the respondents. Accordingly, the registry to list this matter after the ensuing summer vacations on a date to be fixed by.
I am
I appear for 1, 3, 4, and 5.
Mr. D. Bora, Learned Government Advocate, appears, is present for the respondents number 1,
1, 3, 4, and 5.
1, 3, 4, and 5.
Daily list for delivery of order, item 1 to 3.
1, 2, 3, and 4 disposed of, but you will get the orders by Wednesday. Next Wednesday. Tuesday or Wednesday, you'll get the orders. Disposed of.
But there's a small problem with it. But subject to correction, have I won or lost? I put the question to myself.
Huh?
But people are waiting whether we have won or lost. But the 3, 4 cases are there.
You will get it on Tuesday.
Like,
I've only reached the halfway stage.
my lord. Lord. Tuesday. Right.
For admission, item 5.
None appears for the petition on call. For the ends of justice, registry to list this matters again after the ensuing vacation, summer vacations on a date to be fixed by.
Item 6.
Actually, मैं kindly pass madam.
Para come to second round of material. Cut it here. Second, none. It cut it here. It already won like second material. Yes.
Actually, मैं kindly pass madam.
I have the certificates.
Okay, we'll hear it. No problem. But let me just see. There are 2 certificates, 2 dates.
Certificates a lot.
Who is appearing for the petitioner?
R. Hazarika. He's on leg.
No problem. Second time, Mati.
Public.
Item 7.
Two 2006 and applied only in 2021.
Second time.
Item number 8.
Yeah, please answer. So when I
Yes. What is the instruction?
my lord, from my part, no any contact till now.
Okay. The petitioner has instituted the petitioner, who is the second wife of late Rinku Sharma, has instituted the present petition number 1, who is the second wife of late Rinku Sharma, has, along with her minor son, instituted the present proceeding, praying for a share in the pension and pensionary benefits authorized and being received by the respondent number seven, first wife of late Rinku Sharma, on for the petitioner number 2. Also, although the respondent number 7 is represented by a counsel, comma, the learned counsel, Mr. K.U. Ahmed, has submitted that he has not been furnished with any instruction in the matter by the respondent number 1. Also, in view of the said submissions made before this court on the last date of hearing, comma, this court had required the learned counsel, Mr. Ahmed, to download a copy of the said order and forward the same to the respondent number 7, intimating her that the next date of listing of the present matter is fixed today. Also, today, when the matter was listed, Mr. K.U. Ahmed has submitted that he has forwarded a copy of the order dated 11/6/2025. You have forwarded.
That is sent by the petitioner, my lord, not by myself.
Copy. You have served a copy.
Yes, my lord. When I served, my lord, she did not accept, my lord. Thereafter, I served through executive engineer, my lord.
Submitted. But full stop. Today, when the matter is called up, Mr. Zahid has submitted that the copy of the order dated 11/6/2025 on being personally served to the respondent number 7, she had refused to accept the same, and accordingly he had got the said order served upon the respondent number 7 through the
executive engineer.
Executive engineer,
PWD.
I confirm.
PWD, Public Works Department, Golaghat, NH Division. Also, in view of the above position, comma, the hearing of the present matter is deferred till 21/7/2025. It is provided that 21/7 till 4/8/2025. Also, it is provided that until further orders from this court, 50% of the pension received by the petitioner number 1 on account of the services rendered by late Rinku Sharma shall not be released to her. Mr. Ahmed, now you'll get the instructions.
My lord, it is confirmed that they have served a copy.
Confirm. We have accepted that. 50% we have stopped. Mr. B. Sharma, learned standing counsel, AG, our accountant general, bracketed A&E, bracket over Assam, is present.
I'm for this 4 and 5 minutes.
Mr. A. Bhattaji, Mr. B. Sharma, Mr. A. Bhattaji, A. Chakraborty, sorry, A. Chakraborty, learned government advocate, is present for respondent number
4 and 5.
4 and 5, and Mr. Adhar appears for the respondent.
PWD.
Respondent number
Respondent number 1, 2, 3. 1, 2, and 3.
1, 2, and 3. It will report third Soborin, Z. A. Zahid, for the petitioner, Abaki Ekini for the respondent. Star Fisher order. Yeah. 50% we have stopped.
My lord, she is very much aware, my lord.
No, I'm not concerned with the second wife. I'm concerned with the child.
Exactly. This is the advice I have given to my engineer even.
That's there.
My lord, in the top of the order, my lord, as dictated, my lord, here I heard that I have submitted the.
No, I'll KU Ahmed's furnish kora to kati diba. A Zahide kora bole bole. Mo koi di metu.
I'm not
That my idea mo koi. I'll do that.
Item number 10.
No, discuss now.
Maybe.
Next,
Advertisement got lots of, got advertisement lots. It's clearly stated in para 11 lots, column 11.
But can the advertisement be contrary to,
Serial number 11 lots, it is in vernacular lots.
no, but you have put it, আবেদনকারী দুইজনতকৈ অধিক জীৱিত সন্তান থাকিব নালাগিব, right? Not more than two
More than
children,
three ones.
but the act notification 19(7) says, if the children are born before the date of the notification, even if it is more than 3, that will not be applicable. So what do you say on that? Also, Mr. A. Chakraborty, Learned Counsel for the Learned Government Advocate, has placed on record the advertisement issued on 26/5/2022, inviting applications for the post of Gaon Pradhan. Also, in the said advertisement, it is found that one of the eligibility criteria prescribed is that the applicant should not have more than 2 children alive on the last date of submission of such application. Also, the Learned Counsel for the petitioner, by referring to the notification dated 19/7/2019, has submitted that the bar for the restriction imposed under clause 1 under executive instruction number 162 of the executive instruction number 162
2A.
is in relation, is to the effect that an applicant should not have more than 2 living children from a single or multiple partners. However, the proviso thereto provides that in the event that the said restriction would not be applicable in respect of those persons, who have more than 2 children prior to the date of coming into force of this notification dated 19/7/2019. Also, it is the notification dated 19/7/2019 that should hold the field. Also, in view of the above position, who has given you this will be given by the Deputy Commissioner or Upayukta, by the District Commissioner Nalbari, as well as, in view of the above position, the respondent, Mr. A. Chakraborty, shall receive instructions on the said issue from the respondents and apprise this court on the next date of listing. Registry to list these matters on 4/8 on 4/8/2025.
Published.
Item 11.
My lord, the Prakash is on,
We have heard him. We are passing our orders. Tell him if he has something, just he can come and tell me. Otherwise, we are
2 p.m. today.
not 2 p.m. If the list survives, we are here. If it does not survive, then I'll pass the orders. Ask him to be here.
Item 12 and 13.
May I please, Lord, sir? My lord, I am for item number 13, my lord. My lord, in item number 13, they have.
Yes, Mr. Abhimanyu, what is it?
Lordship, already written
I will
has
file
been completed,
evidence,
Lordship,
reply, my lord.
on 12 January, Lordship.
What?
Written examination has already.
Completed. They were given the benefit of relaxation of age.
Yes, Lordship, some of the petitioners were given, Lordship, because there was a writ petition filed, Lordship,
Hmm.
on 18th of
Hmm.
December.
Hmm.
So some protection was given to those people to approach the authority.
These
but
petitioners never applied.
Lordship, Lordship, some of the petitioners never applied, but on that day, Lordship,
Hmm.
few of the application, even though their cases, they have not preferred any case against the order, Lordship, for
Hmm.
knowing their age. Some of the applications were received by the department and they were given their chance to appear in the selection process.
Hmm.
So on 12th January, Lordship, the written was held and thereafter the results are still awaited, Lordship. After this, Lordship, a skill test will be conducted.
Yes, what is your case?
We have filed an affidavit.
Opposition.
We want to file a reply.
No, reply is,
2 weeks time may be granted. Because my lord, in some paragraphs, they admitted that.
they have admitted, you are under
They
NHM, they have
admitted
said
that-
that you have been given a set of reliefs, benefits.
Some set of reliefs were not out.
And have you taken part? You are in Pretty Rani. You are Pretty Rani. Item number,
Some, my lord.
all Assam.
I-
Okay,
next time.
that we will take up.
So my lord, my humble submission.
Now, have your,
I will file
have
reply,
the
my lord.
applicants here applied in pursuance to that?
My lord,
If applied, have they submitted a application for condonation?
my lord, somebody may apply, my lord. I am to obtain instruction.
Lordship,
Who
here
applied or
it is the
who-
president who has
But
filed.
my
it,
humble submission before your lordship,
in
that
item 13,
affidavit in
Lordship.
opposition.
Mr. Sheikh, okay,
Hello.
fine, we accept your prayer.
Yes.
Nilakshi Devi is the
President of the.
president.
Yes.
Has she applied?
My lord,
No, she has not applied.
I have no, sir. Not apply. Did not apply. my lord.
And the secretary. So Lordship, in 13,
Well,
Lordship.
President and secretary both seems to have not applied.
My lord. Certain percentage has been given that this percentage preference will be given to them. But my humble submission.
No, you are praying for regularization, Mr.
My lord,
13 goes.
in
Lordship.
addition to regularization, my lord, other claims is also there. That equal.
No, you come to your prayer.
Equal pay may be paid.
You come to your prayer.
My lord,
Prayer 30, 31.
I'll reply, my lord. Let me-
Okay, fine. We ignored that affidavit.
My lord,
We ignored that affidavit.
my lord.
I'm not even going into that affidavit. Your prayer is for regularization. Show me. This post, there is a procedure prescribed how
My
to
lord, In
recruitment.
that case, my lord, your lordship would be pleased to take their affidavit in opposition, my lord.
Okay. Come to para 10.
No, my lord, state to para 12, my lord.
No, you come to just for my sake, read para 10.
Para 10.
Hmm.
Average of the candidates who have prayed for age condonation of apply to the post of AANM. My lord, some of the candidates applied.
You read further.
My lord, the advertisement was published as per government approval to fill up the vacant post of ANM in various health institutions. Institution of the state. The advertisements were also published earlier to fill up the post of ANM. So this is not the first time that the department is filling up the post of ANM. Moreover, ANM working under National Health Mission Assam get preference in selection and get weightage on working experience marks for that working experience marks. That is not mentioned in the advertisement. my lord.
Fine, they have undertaken.
Yes, my lord. No, my lord, they were given working experience marks. That is not in the connected.
Mr.
advertisement.
Sheikh, Mr.
Hello.
Sheikh, just for
Number
my
one.
understanding,
Experience marks, working
The
experience were
advertisement,
given during
unfortunately-
skill test.
I've got it.
Yes.
The
Some person
advertisement,
had been working for a long time. Yes.
advertisement,
Would not mean that they had acquired a right of.
I've got it. You
regularization.
need not read further.
My lord.
The advertisement is not under challenge in your writ petition. The conditions there are not under challenge. Your only prayer is for regularization.
No, my lord, we want to say that we have completed more than 10 years
Fine.
in service.
Fine.
But thing is this, my lord, in National Health Mission, we are working for 10 years and similar post advertised by the government, regularly recruited. But we are working for 10 years, we have experience.
You
We-
have-
Regularization is not considered at all.
No, you are contractual, you are given an opportunity to apply.
Voilà.
You are facilitated with age condonation. You are facilitated with additional marks. You have not been taking advantage of that. So why should we?
No, my lord, I am not in a
Scuttle a
position, I am
process
not
which is-
in a position to reply at this, my
Okay.
lord. That
On the prayer of Mr. M.A. Sheikh, Learned Counsel for the petitioner, who submits item number 13, who submits that the respondents had filed an affidavit in the matter, and he would like to file a rejoinder thereto on behalf of the petitioner. Full stop. Prayer is not objected to by Mr. D. Upamanyu, Learned Standing Counsel, Health and Family Welfare Department. Full stop. Accordingly, a registry, full stop. Prayer of Mr. Sheikh is accepted. Full stop. The petitioner may file the rejoinder before the next date of listing. Full stop. A registry to list these matters again on 23/7/2025. Full stop. WPC 605.
my lord, another thing is this, my lord, there another similar matter is.
Okay, let me just get over with this.
Yes, sir.
605. Mr. Alamgir, you want to file no, you are
Alamgir-
appearing in item number 12? No.
It is not there. my lord.
Okay, the 605 would likha. None appears for the petitioner on call. Registry to list this matter along with WPC number 148/2025 on Kiman 23/7/2025.
The only thing is this, my lord, another NHM employees matter, my lord, similar matter, WPC 1150 of 2024, it's pending before your lordship. So my case may be listed along with that,
Let it come, we'll see.
my lord. Oblige, your lordship.
Highly approved.
Supplementary list, item 33.
I have received my lord, the record. I have
Please,
received the record.
Records are there. Okay. Show me the records. Where is that relevant page? What is this records, madam? Some Xerox copies? Where is the note sheets?
If they have said that they are putting in an e-file and so they're giving me, they're providing.
Where are the e-file notings? Where are the e-file notings? There would be notings. It's not here. We wanted to see how you have dealt with him after the show cause notice was issued. There is nothing here. For the sake of records, you just Xerox a file and you place it before this court. Where are the note sheets? What happened to the proceedings before the Women Commission?
They forwarded to my lord,
They have forwarded to the director.
Department.
my lord, just I want to mention. I was transferred what was interfered by dishonorable court because there is a troubleshooter was the one lady teacher, my lord, who is the
Hey, Gone,
happened to be a managing committee's chairman's sister.
sister.
So I was that transferred.
Nirmali. Madam.
Yes.
Hmm.
And thereafter, my lord, no, this three lady gone, my lord, they have
Gone.
said that because of the misunderstanding we have filed, they have withdrawn. I am not on that. Then, my lord, after some inquiry, my lord, they put me on, there only a warning has been given. Only one warning. That was also without hearing me. Then I approached the Honorable Court, your lordship pass an order.
We interfered with.
He interfered with, says yes, if you want, you can proceed according to law. That was the judgment passed by your lordship, my lord.
No, I've seen that.
My lord. Now,
Then
what
they
happened,
have
my lord?
now instituted a proceeding against you.
By taking the rescue of that, my lord, they, my lord, suspend me. Already warning was given. I am challenging that warning.
Your suspension is on
On, my lord, that is 19/12/2024. 19/12, my lord. After that, page 72, my lord. Page 72, my lord.
26/11/2024.
No, my lord. Suspension order, which, my lord, he had challenged before this honorable court, my lord. That is page 72, my lord.
72.
72. Page
This is
72, my lord.
1912.
In pursuance to the government order, that government order I am asking for, my lord, by filing a writ petition, my lord. They have not given to me, my lord. But ultimately they have given, my lord. Then I have seen in compliance with the order of your lordship, my lord, they suspend me, my lord. That order I am next, my lord. Page 79(3), my lord. This suspension order, my lord. Now, my lord, they are incorporating some new things in my show cause notice, my lord, which are not in the earlier one.
No, that
But
is.
now, my lord, you have come to see your lordship, kindly see. This is my lord, suspension
Is the
order.
bar, is there any bar to that effect?
There is no bar, my lord. But one thing I am submitting, my lord. 19/12/2024, my suspension order was passed, my lord. Then so cause then in the government order clearly mentioned that within 1 month you have to complete the inquiry. Page 74, last part. Page 74, last part, my lord. Order. Page 74, last part, my lord. After
How
careful,
can they pass this order without issuing a show cause to you?
my lord,
They could not have passed this order without issuing a show cause to you.
my lord. Now, my lord, your lordship, kindly see that this issues, page 75. This is issue the compliance of the Honorable Guwahati High Court order dated 10/1, which is passed by your lordship. Now, my lord, your lordship, kindly say show cause notice. When they were
78.
your lordship, kindly to come to the show cause notice, my lord. Show cause notice, my lord, that is 13/3/2025. Page 75, my lord. Say page 78.
5 charges.
Some new things, all right, my lord. So that was your lordship, can say last but one para. 7 days time was given to give me reply. 7 days time, my lord. Your lordship, kindly see, issued on 13/3, 17 means 20 years. You had up to 27 days will be completed on 23, my lord. But before that, my lord, they reviewed it. Your lordship, kindly see page 88 now. On 13, my lord, issue show cause notice. On 17, they reviewed it, my lord. Without even giving any time to me reply, my lord. They are waiting for reply, my lord. Page 88, my lord. It is a error apparent in the face of the record. Your lordship, kindly see, giving 7 days time, but before that, my lord, but I have already filed my show cause reply. They have reviewed. What is the reason? We have not given any reply from you. That's why I have not reviewed it. Your lordship, kindly see, my lord. Page 88, my lord. Whereas the disciplinary has reviewed the suspension.
So you want this suspension order to be interfered with?
My lord, just to, my lord, your lordship, kindly see their modus operandi, my lord. Give me 7 days time, but within after 4 days they have, my lord, reviewed it. Without waiting for my reply, my lord. But already I have given reply. But reason, your lordship, kindly see, at the time of review, the suspension order, no reply has been received.
Mr. Monto, we are not entertaining your prayer with regard to the order dated 26/11/24 and 13/3/25.
My lord.
Show cause and the orders passed thereon.
My lord.
You will only consider your suspension order and the review. Yes. How was this review made? Review cannot be made by, there has to be a committee. Where is that committee? Record can you? Find that out.
Only on that point. Your lordship kindly got my point, my lord.
And you issued the show cause notice on 1912. You have Ajay Chaudhary with you?
Yes, always should.
Para 21 will read the first 3 lines. The order has to be accompanied by an order
No, my lord.
whether the suspension is to be continued or not. That order admittedly is not passed. No review was made. Madam, ask them to give you this note sheets leading to the issuance of the order dated 17/3/25. We'll have this matter at 2 o'clock.
My lord.
And Mr. Monto, read the your reply that argument may not hold the field. The requirement of Ajay Chaudhary is 3 months from the date of suspension. If you don't issue a show cause notice, gone. If you issue a show cause notice, that has to be accompanied by a order reviewing the suspension order.
That is not there, sir.
Huh?
It is not there.
That is it. So develop here. There are 2 judgments, one by my Lord Justice Borua and one by me. Judgment, I forgot the name. That's the problem. Of J. Patwari. Diganta Kolita. Just get a copy of that.
Can be tomorrow, my lord.
Tomorrow.
Because I have to- Although Shadori is here with me, my lord, but other two. I have to-
That 2 judgments, Diganta Kolita.
My lord, definitely. That tomorrow.
And therein, my Lord Justice Borua's orders
My lord.
I have called. Huh? Prasanto Dotto.
My lord.
He is very excellent.
Yes, yes.
Madam, tomorrow you will give me the note sheets leading to the issuance of the order. Today, in terms of the directions passed by this court wide order dated 18/6/2025, Ms. H. Tarampi has London Standing Council's Secondary Education Department has produced the records. Full stop. On perusal of the records, it is seen that the same are only the documents involved in the matter. The note sheets have not been placed on record. Full stop. Further, the processing made towards issuance of the order dated 17/3/2025, 17/3/2025, issued by the Director of Secondary Education Assam, extending the period of suspension of the petitioner on review, has also not been placed on record. Full stop. On the next date of listing, Ms. H. Tarampi shall receive the said records and place the same before this court. Full stop. Registry to list this matter again tomorrow.
Deeply.
To buy sleep.
Daily list for orders, item 14.
Please, Your Lordship, last order was for the respondent to get some instructions. Order dated 13/6/25.
Who is the respondent? Dina. Get hold of Mr. Nutt. Get hold of Mr. D. Nutt, Senior Government Advocate. Or Mr. R. Sahini, his junior. He is also an advocate.
Supplementary list, item 34.
The content petition on last occasion was directed to take the instruction also. Because judgment has been passed since 2022, till date pension has been released.
Ah, that old, yes.
Preferred, my lord.
When?
It's on 17th of June, my lord. It's like,
Delay,
well, delay is gone.
condoned.
So appeal is,
What is the appeal number?
the serial number is 7710/2025.
7710 filing number.
Filing.
And the delay was condoned,
But delay that order, I don't have it, my lord.
but it was condoned.
NJ Kataniar has filed it, my lord. I have been informed that it is filed on 17th June. I've checked up in the e-code, my lord, it's 17th June.
No, no,
Fine,
no.
ma'am.
Whether the delay has been
Perhaps,
condoned.
my lord, I don't know.
Also, Mr. B. Kaushik, learned, heard Mr. S.K. Goswami, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned counsel, appearing for the respondent number 2. Mr. Kaushik submits that the state respondents have preferred a appeal against the order dated 10/5/2022 passed by the coordinate bench in WPC number 3920/2021, and the same is pending consideration. Also, in view of the above position, registry to list these matters again on, we'll give them a month's time.
My lord.
Today is
19.
19. On 28, no, 30 ko diya, 37/2025. On the next date of listing, Mr. Kaushik shall apprise this court about the orders that may have been so passed in the appeal stated to be filed in the matter by the state respondents.
Straightforward.
Stated to have been filed. Hearing any continue for now.
For hearing, item 15.
In this matter, senior counsel will appear in this matter. Please
Colin, he is most welcome.
take some other court.
No problem.
Can timing your.
Timing. Timing. You are paying for?
Put the respondent, person you
You have not appeared before.
I paid
Your name is not item number?
item 15.
15.
15. Oh, sorry. Raval. Okay. Who is appearing?
Mr. D said.
No? Okay. Okay. Whenever matter permits.
Item 16.
Yes, Mr. Varpuzari, what have you got?
One aspect of the matter.
Just to, for my understanding, Hussain Ali was appointed as a sub-registrar,
On commission basis.
be that as it may.
By the
He set up a sub-registry.
Yes.
He set up a sub-registry. For the works involved therein, he appointed Siddiq Ali. And that sub-registry that was working was held to be, was empowered like a normal sub-registry that the government had set up. Thereafter, the sub-registry, now it is not Hussain Ali whose services were taken over. It was the sub-registry services that were taken over.
Entire sub-registry
Registry was taken over.
got converted into a regular establishment.
For my understanding, with the 786 old chip, so I'll call it that you had taken over the sub-registry as a whole. So, once you have regularized people in that sub-registry, that means you have recognized their past service.
We have recognized their past services, but because of the fact that in the meantime, the new pension rules have come up.
That we will come. That we will come. So you have recognized their past services.
Absolutely.
So without that service, their regularization or anything would not have been permissible. Now Hussein Ali retires. He is given he said that you are under the NPS, not OPS. He approaches this court. This court holds that no, that whole length will be required to be reckoned.
Because
And if the whole length is taken, then his appointment goes beyond 1 to 2005.
it starts from the very initial date in the year 1984.
84. Even a 1 day before that is also enough.
Yes, yes.
So you take it up on appeal. Appeal, the order is reiterated and cemented further.
Cemented further.
Now, Siddiq Ali gets the spark
Yes,
and he comes.
he comes.
Now, I draw the analogy of 25/2009 notification in respect of casual, Mazdoor, all those people. The period of service, casual, regular, master role, work charge, you have added it. And once you added it, they go beyond 1 to 2005. Otherwise, they would have been post 1 to 2005.
Post 1 to 2000.
All those employees. Why that analogy in the given fact circumstances shall not be applied?
Yes.
You have done, you can relax. Yes.
Now, one additional affidavit, if Lordship may be.
No. Give me, give me serially. Otherwise, it will not register.
Therefore, my lord, facts are not in dispute.
So
Facts.
this is accepted.
Facts.
These facts are accepted.
Sir, it is there on record.
Okay,
because
fine.
It is not a fresh appointment. From the tenor of the language, my lord, inculcated in, my lord, page 39 of the writ petition. Services is pleased to regularize, the Governor of Assam is pleased to regularize the services of the following employees of Mukalmua Commission Basis Sub Registry so and so, shown against each of their names with effect from the date of creation of the post. Lordship will kindly mark this. If for a moment Lordship comes to page 39 of the writ petition. Page 39 of the writ petition would go to show when those posts were created, because admittedly prior to that, it was not a regular cadre post, not even a sanctioned post. Page 39, Lordship will find in the middle portion 3 columns. First column is with regard to the name and designation of the employees. Second column, Lordship will find nomenclature of the sanctioned post. Third column assumes significance here. Sanctioning letter and date. Sanctioning letter and date, Lordship will find that it is.
Mr. Barpujari, just to cut the matter short, what is regularization?
Regularization, my lord.
What do you mean by regularization?
My lord, although
Can
here,
it be, just for my understanding, can it be that person A is there, you go and regularize it? Or person A has some sort of a service for some length, maybe 1 day, maybe 10 years, maybe 20 years, whatever it is. You say, okay, because of this length of service, we are not requiring you to apply afresh, appoint you. We are creating a post and we are accommodating you against that.
admittedly appears to be a case of regularization, because regularization can be done only, my lord, on an existing post.
No,
Existing post.
regularization can be done in an existing post,
and the
but
person
can be only in case of a person who has a service prior to that.
Absolutely, absolutely.
Hmm.
Now, during the proceedings of the present writ petition, if Lordship may be pleased to take up, this matter came up for, well, at 13/3/25. If Lordship may be pleased to take up order dated 13/3/25.
In the present proceedings,
Yes,
13-3.
25. Because at that point of time, this honorable court was of the opinion that if the petitioner has already made contributions, or reversely, if the contributions pertaining to NPS has been deducted from the petitioner's salary, then the matter would be different. Because he has not challenged that NPS deduction per se in the present writ proceeding. But that means he has waived, he has accepted it, then it would be different. So we were directed. Accordingly, the revenue authorities have filed an additional affidavit, which Lordship will find from running page 138. Now, to this affidavit, no reply has come from the petitioner's side.
You are referring to para?
Well, at para 6, page 140.
Correct it. Your affidavit starts from, as per the registry made running number 149.
149. Well,
It will be 151. No problem.
I'm so sorry.
No problem. Both the numbers are there. There will be no issue. Yes.
Well, at paragraph number 6, the deponent respectfully states, now this affidavit is filed by the Inspector General of Registration. The deponent begs to state from the records available in the office of Sub-Registrar Mukalma, Nalbari, it transpires that a contributory deposit under the new pension scheme in respect of the petitioner was maintained by the competent authorities under the new pension scheme, and the said fact has also been admitted by the petitioner in the additional affidavit filed on 23/2025. Now, here Lordship will kindly come to the annexures.
What is the contribution permissible under Tier 1 and Tier 2? 10%.
10%.
Of the basic pay or full pay?
Okay.
Full pay.
Now here, Lordship will kindly see, my lord, Annexure A. These are the pay bills. In Annexure A, Lordship will kindly come to the second page, my lord. That here in my office copy, it is page 143. Perhaps, my lord, Lordship, it will be
154. No problem.
Yes, my lord. There, in the second page of this bunch of Annexure A, Lordship will kindly see, my lord, on the right-hand side down below, deduction. B.
So this deduction is in respect of all the employees there?
No, with respect to the petitioner.
No. Here everybody is there. How can you say that this is only in respect of the petition?
Yes, yes. All other employees. The deduction is with regard to NPS. At column B, it is written.
Has the amount under NPS been released to him?
No, it will be released only after retirement.
He is not retired. Oh, he is in service.
No, he has retired. By now,
Yes.
he has retired.
So have you got that amount?
Taken it back.
Yes.
Because before my retirement, I filed a representation. After that, my Lord Justice Ujjwal Bhoya's judgment that I am also entitled under old pension. So that this is.
So if the judgment had not come, you would not have been entitled. You will not have been interested.
Out in that judgment.
No, this is
We have to see whether I am entitled or not.
that.
So
I have not.
this
taken
will
it
be,
back.
Mr. Bhattpujari, if we finally conclude that Siddiq Ali is entitled to Hussain Ali's benefit, then this money will go to the government.
Yes, yes. I have not taken
No,
it.
but because
Your government contribution here will go back to you. His contribution he can take.
no, his contribution, because this appears to be the distinguishing factor, because in Hussain Ali.
No, Siddiq Hussain Ali also is.
No, he has not brought any material on record to show, because Hussain Ali pleadings are not before this honorable court. Whether Hussain Ali, my lord, a stand was taken, my lord, that the amount was already deducted and these particulars were laid before this honorable court. Here is the case, my lord, where we have come up with the pleadings and have laid the material.
Have you said somewhere that Hussain Ali was not covered by the old pension, by the NPS?
No, my lord, it was all along our pleaded case there. If Lordship takes up the Hussain Ali, my lord, read appellate judgment. or for that matter, my lord, the learned single judge judgment, my lord, that is a part of the additional affidavit filed by the writ petitioner. It starts from running page 98.
Where is the appellate order?
Yes, appellate order, lordship will find in the same affidavit, my lord, it starts from running page 114. 125. And it's a 30. In my digital liquidity. Because Hussain Ali has, in Hussain Ali, challenge was also laid with regard to that condition of, to the fact that he has to give an undertaking, my lord, that he will be covered by the new pension scheme. At that stage itself, my lord, Hussain Ali came before his honorable court. And what I find, my lord, from the judgment and order of the learned single judge, as well as, my lord, of the writ appellate court, there is no finding that NPS was deducted in respect of Hussain Ali.
Paragraph 17, very clear. Division bench judgment.
I asked you to relax. I asked you to relax.
Now, in the additional affidavit annexure A, which lordship has seen,
So
well,
tell me,
there is no
where
mention.
is the restraint order in respect of Hussain Ali directed by this court that don't cut his MPS?
No, there is no
He is
restriction.
also deemed to be under MPS.
Therefore, but if no deduction was made in respect of Hussain Ali,
No need. We'll go by law. Anybody who is coming after 1/2/2005, he is NPS, not OPS. So we'll not go beyond that until and unless you show that as a special case, he was excluded. You had not excluded him. Otherwise, if you had excluded him from NPS, this proceedings would not have arisen. Then why should we go into that issue?
true, because what is the consequence? Because he was brought under the purview of the new pension scheme, to which he laid a challenge before his honorable court, and there was nothing available on, no material was available before his honorable court, even to remotely suggest
We
that
will not go into that. We deem it that he was also under NPS.
he was NPS, but whether any deduction was made, if deduction was
If,
made,
if deduction is not made, it is deemed to have been made. You should have made it. If you have not made, it will be deemed to have been made.
deemed to have been, that will altogether.
He cannot be, Mr. Barpujari, an employee, because of the safety net, cannot remain out of these two things. Earlier, there was an option whether you want CPF or pension, right? that option has to be exercised. If no option is exercised, he is brought into the pension scheme. If option is exercised that he wants to remain in CPF, he'll continue in CPF. Now, following the same analogy, why should we go into non-issues? Reserve that.
No, non-issues because
Reserve that for future.
that is, Lordship can definitely take a call on it. But my lord, so far as this Annexure A, which is a part of this additional affidavit, Lordship will kindly see there is no Hussain Ali's name do not figure here.
Forget it. We are not going into that. Next point. We have record. We'll take your note. We'll take your point on that.
Then one more affidavit, my lord, the Revenue Department has filed, my lord, on my lord 16th of May. It starts, my lord, from running page 151. But perhaps again, my lord,
Lasit Kumar Das.
yes, Lasit Kumar Das, their lordship will kindly come to paragraph 5 and 6, my lord.
Yes, next.
No, my lord, neither in Hussain Ali, neither, my lord, by the learned single judge, of course, that was not placed before this honorable court, nor the lead appellate court had the occasion, my lord, to arrive at a finding with regard to, my lord, amendment made to
That we have noticed.
Pension
We have noticed. You can
my
go to the
humble-
next point.
my humble submission will be, my lord.
That is the distinguishing factor.
That is the distinguishing factor, and those judgments are par inferium. So,
Okay.
and how it is par inferium, I will satisfy. Purnima Hore, my lord, lordship is well aware of that Purnima Hore.
I'm not aware of anything.
Yes, Purnima Hore, I will be placing, my lord. Now, amendment made to the pension rules that those employees who come into, my lord, appointment post 1/2/2005 will be governed by the new pension scheme. That is, there is a statutory bar, which was raised, of course, my lord, in Purnima Hore, and it was addressed. But that aspect of the matter was not raised, maybe, my lord, by us even, my lord, before the learned single judge.
Purnima Hore, which
Yes.
paragraph?
Lordship will kindly take this, my lord. Paragraph 8.
Paragraph?
Paragraph 8. It will be, my lord, paste down below. Well, paragraph 8, if I may read it, my lord, because it
No.
discuss
Just go
it.
to the.
Yes. Then down below, my lord, in page 321, lordship will find a replica of that notification. It has been reproduced in the judgment itself. There, lordship will find insertion of new rule 2A. Provisions of this rule shall not apply to government servants appointed on or after 1/2/2005 to the services and posts in connection with the affairs of the state government which are born on pensionable estate. That is why, my lord, on the last occasion, I made a submission with regard to the terminology that is called pensionable establishment. Because prior to regularization in the year 2008, this person.
Where are the conclusions you want to rely on of the coordinate bench?
Yes, my lord. Lordship may kindly come, my lord, to paragraph 18,
I'm there.
pensionable establishment. These are long paragraphs, my lord. I need not read it out, my lord. Lordship will take a note of this, my lord.
Okay, next.
Next, Lordship will kindly, my lord, kindly see, my lord, paragraph 42. Paragraph 42. At this stage, Lordship may kindly mark the paragraphs, my lord. Because what would amount to a binding precedent?
Page?
Page 348.
No, not 348. Oh, the internal page 348.
Internal page, because I have given, my lord, the judgment as it is, my lord. It has also been reported, my lord.
42.
42. On the other hand, it is the submission of learned counsel on behalf of the finance department so that persons were a judgment for inquiry. I mean, as such are not binding precedents. Reference was made in this regard to the judgment of the Supreme Court rendered in the case of state of Kerala so and so. As regards order dated first in review petition so and so, the judgment cannot be said to be as a binding precedent in view of the rule of sub silento.
Done. Got it. Then?
Colonel B.J. Akara, that is a classic case. Lordship is aware of it, madam. The mention has been made at paragraph, my lord. Of course, in the next page, running page number 349, my lord. Internal page.
2006-11.
Yes, my lord. Yes. It's a classic case, my lord. Lordship is well aware.
That is your presumption.
Then paragraph.
Here, Jiban Chandra Deka was distinguished, holding that pension word that is there would mean the pension in operation on the date of regularization. It cannot mean the Assam services pension rules per se. That was the basis of proceeding to reject the cases of the drop teachers.
Drop teachers. And say that, but since government at one point of time had Jiban Deka had attained finality, no further, my lord, agitation was there from the state. And my lord, in pursuance of Jiban Chandra Deka, so many decisions came to be, my lord, passed by this honorable court, and government has accepted it.
I was one of the councils on that side
now,
addressing the court with regard to stipendary teachers.
Stipendary. Now, of
that
course,
was allowed.
Stipendary was allowed. Then, my lord, paragraph 44, my lord. Those were the judgments relied by, my lord.
You'll consider it.
Yes. The paragraph 45 onwards, my lord, Lordship will find the reasonings, my lord. Now, if at one point of time the state had allowed, my lord, the judgments and orders passed by a high court, my lord, in exercise of powers under 226, and those have attained finality and government has not hesitated at that relevant point of time, that does fact of debar the government to raise the same contention in.
I remember that argument being raised and that being dealt with.
Yes, we have also taken a cue from a decision of the Honorable Apex Court. That also Lordship will find here. And then my pension, the new pension rule itself goes to show, my lord, that from 1 to 2005, those who are appointed or regularized, they will come under the ambit of, my lord, the new pension. And as on as on 1984, my lord. This person, Siddiq Ali, he was not born out of any pensionable establishment. The pensionable establishment was created per se for the first time with effect from the date of regularization. That is why Lordship will find there are two orders from the government. First is my lord, technically to say it's a provincialization of the institution itself. That Lordship will find at page 38 of the writ petition. Page 38 and 39. These are the two vital documents. Page 38, Lordship will kindly see, this is the notification whereby the Governor of Assam is pleased to convert the following 5 existing commission basis members with effect from the date of posting of departmental officers and subordinate staff. The commission.
You come to page 39.
Yes, 39. 39, Lordship has just now seen.
You just after the names of the persons regularized.
Yes. And undertaking.
An undertaking is applicable to Hussain Ali also.
The undertaking was applicable because.
Okay, got it. Next what?
This much, my lord.
This much. Yes, what is your reply?
But I know where from I will start. Last time.
I have.
I don't know where from you will start.
Lordship.
This is going live. Your client may be seeing.
Lordship,
He will have a heart attack.
have to convince.
I had made my
regarding
submission on behalf of Finance Department. My brother will make submission revenue.
You give me a written note of yours. Yes,
First thing regarding the establishment of registration.
I'm not interested.
Then
I am not interested. You reply to what Mr. Borpujari has argued. That,
regarding. Yes,
that
I'm fine.
only on the ground that Hussain Ali was also covered under the NPS scheme. But he had been subsequently given the pension and pensionary benefits. He takes a plea that this aspect was not argued, but it was a valid point which ought to have been argued. However, I add a line to that for getting a response from you. As far as Hussain Ali is concerned, there was another dimension. That dimension was that he was getting a commission. And the learned single judge, while deciding the writ petition, held that the commission that he is getting is akin to a salary. And the simile was drawn between a regular established registry and a registry running on contractual, on commission basis. That is how it proceeded. You were not getting a commission from the government. You were getting a commission out of the commission given by Hussain Ali. And you have not said whether you are getting a commission or a salary.
I have.
You have not.
I got committee.
Where? Where have you stated that?
Yes,
Where have you stated that?
in my main writ petition as well as in the.
No, you get me the writ petition first. Where? Commission basis lower division.
Paragraph 4.
And this commission was not given to you by the government?
It was given by Hussain. On that point, Lordship, last time instructed me to sort certain decisions. That delegation, agent, Supreme Court, 1977 3 But a small difference is there because there was service rule in our case. Service rule was not.
Oh, extra departmental post.
Extra
Don't bring that. Next,
Then-
next.
Regarding the delegation.
Extra departmental agents, they are recognized. There are they have posts. Then next.
Regarding this delegation,
Oh.
Lordship,
Hmm.
parting with power, delegation. Please kindly come to.
No.
page 38.
Here there is no sub-delegation. There is no sub-delegation, Mr. Be very careful. There is no sub-delegation. It is, I told you on the last occasion also, it is a convenience of Hussein Ali that he got you in. It's not a sub-delegation. It is his convenience. Your only plank to stand is the order of regularization.
Order of,
Regularization, page 39.
and Lordship,
You show me that order of regularization will have to be construed in the light of the services rendered by. Join this up, take it beyond 1/2/2005.
Lordship.
You have the orders.
For a moment, kindly have a look at the division-based judgment. Page 133 of my additional letter.
Para.
Para 17. Our services were considered not only of Hussein Ali, but the entire staff establishment, considering the services rendered by the respondent and his peers. So they should have gone for appeal. His peers in total of 5 sub-registry offices to be perennial, satisfactory and indispensable. A notification dated 22.
Mr.
and
Consul
his
Islam,
peers.
this is in relation or qua Hussein Ali. You are not there. You were not that you were indispensable. If you were not there, Hussein Ali would have got somebody else. Here the condition is from the government on Hussein Ali that don't take any other employment when you are taking a commission. That thing cannot be brought and read in your case. Or show me how will I read it in your case. It will be very easy for me to pass an order in your favor then.
In the sense that Hussein Ali himself cannot cannot engage himself.
But that condition will not apply to Siddiq Ali. Siddiq Ali can do whatever he wants to do.
But I was
Siddiq Ali does not like, Hussein Ali does not like Siddiq Ali's face. He may ask him, go, we don't want you. Nobody was there to protect you. But Hussein Ali had a sort of a cover of protection with regard to the services rendered by. That is why the judgment of my Lord Justice Ujjal Bhuiyan comes in. He drew the analogy that commission is akin to salary. You were not given a separate commission. And what is the basis of that commission, Mr.? How is that commission determined?
It was determined, my lord, on the basis of, my lord, the number of registration made.
The expenses are not included therein.
No. Because there was a no.
Mr. Islam, is the expenses of the institution or the establishment included in that commission?
of course,
Argue on that lines. That's why I gave you time. Come on, where? Show me something. I'm there with you. Still, I'm not with Mr. Borpujari still. But the court is slightly sliding
Lordship,
towards the other side.
servant and principal
You-
agent.
No. No. Sorry, that argument is not acceptable.
That answer, lordship will find it at page 24 of the writ petition.
24.
Yes. Second paragraph. The newly appointed commission-based sub-registrar will be remunerated in accordance with provisions contained in para 50 of chapter 5 as per instruction and order contained in registration manual Assam. Necessary office accommodation to be arranged by him at his own cost. Books, forms, etc. will be supplied to him by the Inspector General of Registration. If necessary, he may arrange the office establishment at his own cost, at his own responsibility.
This was what you should have pointed out in the first phase.
He is not allowed to take any other employment during the period of his income.
Hussein Ali.
Hussein Ali. Now, my lord, the parameters on which, my lord, the commission was drawn by Hussein Ali, it is to be found, my lord, at page 24.
No, 24. That's what I did not have this That's what I was telling him, whether these are the expenses he makes from the commission.
He receives commission. But
Anything more? Your vacation will go. If you don't give me anything, you will have to draft an appeal.
Lordship, in that case.
Or Mr. Borpuzari will do that.
Lordship, very thin area. So,
Okay, do one thing. Give me a written note, whatever you want to say. You are here, I can't go. Give me a written note.
last occasion, Lordship told about delegation of power.
Cannot be. Page 24 makes it very clear.
At his own cost and responsibility.
Apply your mind. Monday, give me a note.
Monday.
Tuesday. Judgments I'll pass only after the vacations.
After the vacation,
No. Tuesday.
Tuesday.
Huh.
Tuesday.
Hard day parties at length. Full stop.
24 and 26 both I cases.
You have cases. Who said you don't have cases? Otherwise, why will you come to the High Court?
24.
Huh?
This one.
You are here because you have cases. Otherwise, you will come here for Adda.
All that 26.
25. Okay, 25. On, I heard hearing remains inconclusive. Raised it to list this matter again on 25/6/2024. Mr. Islam, try to work on these areas.
Lordship to specify the area.
Why should I? Why should I? You specify. Now the issues are clear with me. Counter what he has said. It is there online. Hear it today night. Then work it out. You have at least stopped me from passing the order today.
we can only plead, my lord. We can only plead.
No, I should also appreciate.
Because other things, Usanavi also gave undertaking, he also deposited the NPS.
Show me that he was, I have seen that. That Hussain Ali's also NPS was being deducted.
Yes.
Show that.
This is how, my lord, we are trying to
He
decide.
has also given undertaking.
Mr. Counsel, don't go for the big case laws. First, you clear up your facts. Lay your facts bare, then the law will follow. Get my point? Or you leave it to me, I'll pass the order.
I'll satisfy you.
Okay. On 25th, you are giving me the written arguments. Both of you. No further arguments. Only the written argument. You also, if you want, you can submit.
Yes.
The parties are at liberty to make their written submissions, to place on record their written submissions on the next date of listing, along with the case laws relied upon by them. So 25th.
Purnima for a decision, lordship may kindly retain it, my lord.
So you can give it to me together.
My lord,
I have my markings in my book, so that will be more easier.
my lord.
You can just make that reference only.
Yes, absolutely.
Item 17 to 19.
There is.
Lordship, my senior is on lakes on court number 10. Kindly pick
On the prayer of the learned counsel for the parties, registry to list this matters after the ensuing vacations. Dismissal adjourned, dismissal deferred. Dismissal deferred. I have read this file twice this week. I'm not reading it anymore.
Can you pick this case?
No, I'm not reading anymore. We have enough matters to do. Now, Mr. I. Chaudhary and Mr. B.D. Dekar are waiting for a big series. I forgot everything. I'll have to hear them again now. So the whole day will go. Done. Next.
Item number 20.
Departmental proceedings, pleadings complete.
Little lords.
heard the learned counsel for the parties. So it is stated at the bar that the pleadings have been completed and the matter can be taken up for final disposal. Accordingly, admit the appeal, registry to list this matter for hearing in the month of August on a date to be fixed by it. So on the next date of listing, Mr. J.K. Goswami, Mr. J.K. Goswami, appearing for the respondent bank, shall keep the records of the departmental proceeding ready. Yes, Mr. Ahmed, what are you waiting for? Oh, Arun Sharma.
Heading item number 35 and 36. 36 I am appealing, madam. 30.
Oh, jury Rani, oh, we had kept it, but okay, we'll consider.
Okay.
It was taken up, but nobody was there, so we had adjourned the matter. Or time being. Yes.
21 to 28.
Can this matter be taken up at 2?
Where is Mr. Chaudhary?
Your lordship, I think Mr. Chaudhary is on his legs, the junior is calling.
Okay, at 2.
My
It
lord.
will not be at 2, a little bit after 2.
Yeah.
Ask Mr. B.D. Decker to renew. I have forgotten everything.
Lordship.
Mr. Decker seems to be on legs, so let him come. You're here?
Yeah,
I have forgotten.
naturally, it has been quite some time.
My notes have also been misplaced. Okay.
Item 29.
Yes, who is for the petitioner?
Lordship, last occasion,
I wanted to learn some maths today on this case.
Lordship record have to be.
Record, forget it. Get hold of the petitioner.
In this matter, Lordship,
I don't know anything. You get the petitioner.
Stutia will be repeated.
Oh, whoever you, after I finish with the petitioner only, I'll require you. So first, let me get over with the petitioner. Ms. Barua, the only allegation, only plea taken is that her date of retirement is 31/3/2023. Mr. Alvin. No, need not be sorry. I was waiting for you to learn some maths today. Okay. Let us learn some maths today. My maths is otherwise very weak. You will have to now explain.
Lordship.
What is your case?
Lordship, here in this matter, Lordship, I am seeking notional promotion.
Notional promotion. What is the ground?
Lordship, the petitioner is already retired.
Fine.
Lordship, firstly, Lordship.
You can give me the dates of
Lordship.
the promotion and the exercises, selection date, DPC date. If you have that, give me those.
First is Lordship, the initial appointment of the petitioner,
Hmm.
that is 13/7/1990.
Appointed as
He was first appointed as investigator
investigator.
in the office of the Deputy Director, Town and Country Planning.
Now the next promotional is research assistant.
Lordship, RA. Then Lordship, there was an inter-se seniority list, 4/12/2021.
Wait, just a moment. Promotion is
Inter-se seniority list.
okay, what do you call that?
Inter-se seniority list, Lordship.
No. Research assistant.
Lordship.
Okay. Inter-se seniority list.
Lordship. That Lordship will find at page 33, that is of 4/12/2021, the date.
Page 31.
33, Lordship.
33,
Type
okay.
please.
33 inter-se seniority.
Serial number 9, Lordship.
Indrajit Talukdar.
Lordship, that is
So
petitioner.
date of birth is 28/2/2023.
Superannuation, Lordship. Date of super.
Sorry, superannuation.
Lord, 28.
Now
that
you
is
continue till 31/3/2023.
Lordship.
Now the issue is whether you retire on 31/3
Yes, Lordship.
or on 28/2.
I have retired on 31/3, Lordship.
Actual date of retirement, that is what we have to decide.
Lordship.
Whether you ought to have retired on 28/2 or you ought to have retired on 31/3.
Lordship.
What is your date of birth?
Lordship. Date of birth, Lordship. Date of
So,
birth is
Ms.
1
Talukdar, let's get the things clear.
Lordship,
If we hold that you are continued till 31/3/2023,
Lordship,
promotions having taken place before that,
Lordship,
and your juniors having been promoted,
Lordship,
you are also entitled at least to a notional thing.
Lordship,
That's it.
Lordship.
But if your 28.2 is correct, you're not entitled to anything. If
But-
28.2 is correct,
Correct, Lordship.
then you're not
That is
entitled.
correct, Lordship. 28.2 is wrong here because I have written.
Fine.
Lordship.
We'll come to whether it's right or wrong.
Yes,
But if it is 28.2,
Lordship.
then you're not entitled to anything. Are fact.
Lordship, Lordship, Lordship.
Now you tell me
Lordship.
how 28.2 is wrong and 31.3 is correct.
Lordship, there is a.
What is your date of
Lordship.
birth?
Lordship,
Date of birth.
Lordship, 1/3/1963. 1/3/1963, and Lordship, there is an OM, Lordship, regarding the calculation date of birth. That is at page 27. By virtue of that OM, Lordship, the date of superannuation has been later rectified and held as 31/3, Lordship. But
Now
they
you
have
come to
recorded
that OM. Come to that OM. Come from the second paragraph.
Lordship.
So your date of birth falls on the first day of a month.
Lordship.
Now see, and there is no further days because it's the first day.
Lordship.
Okay, now you read the second paragraph and then tell me what I should do. I'll do that exactly.
Lordship, the second paragraph.
Mm.
In this connection, this one, Lordship.
Mm.
In this connection, it may be mentioned that there should not be any confusion into the matter as explanation is already provided below FR 56A of the FR and SR, from which it is clear that a government servant whose date of birth falls on the first day of any month shall have attained the age of superannuation on the afternoon of the last day of the preceding month, and that a government servant whose date of birth falls on days other than first day of a month shall attain the age of superannuation on the last day of the month.
So it says if the date of birth is on the first day, your superannuation would be on the preceding day of the last month or on the last day of the preceding month. Right? Now you read this, read the second line. So, third paragraph.
For example, if the age of a candidate be mentioned in the old HSLC, HSSLC pass certificate admit card as 15 years, 10 months, 1 day on 1st March 1999, his date of birth should be computed as 1st May 1983, and the government servant shall retire on superannuation on 30th April 2043.
So yours is 1/3/1963. So your date of retirement would be a day prior. That is 28/2/2023.
If I have explained.
So somebody made you continue till 31/3. That 1 month may be re-employment, not beyond that. We will not say anything on that. But you're not entitled to the promotion because you have already superannuated on 28/2/2023.
If I have explained this part on page 9. May I
9.
Of the writ petition, Lord.
Okay, we'll see that.
Lordship, the second paragraph, it may be mentioned herein that originally the date of birth of the petitioner as reflected in the HSLC certificate is 15 years, so and so days as 1st March 1978. However, by virtue of the aforesaid OM dated 31/10/2012, the actual date of birth has been computed as 2nd March 1963, and his date of superannuation is 31/3/2020.
Show me how. Show me how. We have the we have the OM before us.
Lordship.
We need not go anywhere else. Apply that. Same thing. Yours is 1/3/1963.
1/3/1978, Lordship.
This is 1/3/1999. And the date of birth is 1/5/1983. So it is date of superannuation is 34. Anything else?
Take the matter two, I'll check one.
Okay,
I'll
done.
calculate once.
Done. For your satisfaction. Okay. I thought you will show me some new maths today.
No, Lordship.
Okay. এটা বুঝিনি। What time? বা আছে নেকি আর বড় বড় না হিয়ারিং হয়ে গেছে না কিবা থাকি গ'ল নেকি না এটা নেক্সট আর ইয়াত কেইটা আছে এইকেইটা মাতি দিয়ক না 30, 31, 32.
Yes.
We'll have it after vacations. This will have to have some hearing.
30, 31.
30, 31. As agreed to by the Learned Council for the parties, a registry to list this matters again on
After the
After
vacation.
whenever. Give me a hearing day.
17th, Lordship.
Hmm?
17th,
Put it in the next week, 22nd.
Lordship, before vacation.
After vacation,
After
22nd. As agreed to by the Learned Council for the parties, registry to list this matters again for hearing on 22/7/2025. 32. The pleadings are complete.
Lordship.
Only a small area is there. Earlier proceedings interfered with, subsequently again new proceedings. As agreed to by the Learned Council for the parties, a registry to list this matter again on 24/7/2025. You get the records. You have
Yes.
also the records, Ms. B. Sharma, Learned CGC, appearing for the respondent submit that she has received the original records, comma, full stop. The records be retained by the Learned Council and produced before this court on the next date of listing. Yes,
35, 36.
35, 36.
35, 36 supplementary.
Ito kuniwo lang.
Then timing.
Ito thakil ki timing matters. Oh. 5, 6, 7, 11, 14. Mr. Prasad was here. Yes, Mr. Prasad, anything to add in this matters? Okay, 2 o'clock. 2 o'clock. Duta was it? Arunachal to Agusta. Huh? Why you had a matter? Yes, Mr. Nath will not detain you. Which was your matter? 14.
Well, yesterday they have received the report from the district social welfare officer. Today they are going to pass the order. Tomorrow, Lordship can take, I'll place the order.
Okay. Mr. Nath, Learned Council, item number 14.
Item 14.
Mr. Nath, Learned Council for the petition, for the respondent submits that the
It is under
matter
final consideration.
for towards compliance of the directions passed by this court
Lordship.
is being actively pursued and the orders thereon would be passed by tomorrow. Tomorrow, kali date to koidia. So accordingly, he submits that the matter be taken up on Monday, on which date he shall place on record the orders passed in pursuance to the directions in pursuance to the directions contained in the order dated
29/24.
2/9/2024, passed in WPC number
5619/17.
5619/17. So registry to list this matter again on 23. By slip kori dibo.
But to bring on record, has to file an affidavit or?
No, you can just give me an order. Mr. Not giving an order is enough for us.
I'll place.
Arup,
Lordship,
All
item
right.
number 29 will, after vacation. Or
huh?
item number 29.
Madam, you wait. Wait. Let Ms. Talukdar satisfy, then we will go to you. Let Ms. Talukdar satisfy that she has a case, then we will come to you. Why this? After winter vacations, we'll take it up if required. But first, she will have to satisfy. Because that man who is sitting there, because of this case, he is having a hope. Get my point? We don't want that. If he is having a case, we'll give him. If not, we will cut that hope today itself. He can live peaceful. Because we are here. But the person who is responsible for us being here is the most tensed person. Why extend the agony? If he gets the relief, he gets it. If he not, finished. 2 o'clock.
1, matter pertaining to Itanagar bench.
Madam Doji, Madam Age. Finally, we have come to the conclusion. It is 304 part 2.
Yes, Lordship.
And the penalty, the imprisonment has been reduced to 7 years.
Lordship.
Ms. Doji, 7 years. Because only for the factor that he let her die. Otherwise, I was under the impression that it should have been 5 years, but those evidences that he was there, he has not refuted. So intention was not there. The trial court has also held that there was no motive. But the incident he accepted.
Yes,
So,
Lordship.
304 part 2, 7 years.
Yes, sir.
You will get the order by Monday or Tuesday. You can apply for the copies.
Obliged, Lordship. Obliged, ma'am.
Discuss. Yes, Mr.
There is an item number 15.
We'll take it up.
In this matter, Lordship, I was engaged yesterday.
Huh.
I need some time to go through the papers. And,
Whenever you want it.
after the vacation,
Huh.
24th or 25th.
Whenever.
Yes, Lordship, could it be on 24th of
Can you
July?
inform Mr. Kayal also? Huh? Who is appearing with you? Yes?
Sarkar.
Ms. S. Sarkar, counsel for the petitioner has submitted that the petitioner has engaged Mr. D. Saikia, learned senior counsel, to argue the matter on its behalf. Accordingly, she submits that the case be taken up, the matter be taken up after the ensuing summer vacations. Also, prayer is not objected to by the learned counsel for the respondents. Accordingly, a registry to list these matters again on when, Mr.
20, let it be on 29th of July.
29/7/2025.
Deeply obliged.
And only thing that is bothering me in this case is subsequent procedure order by my Lord Justice Bonojit Punya, wherein he has recorded a finding that there is no jurisdictional error in taking the matter forward. Otherwise, I was convinced with the first part that the reason to believe was not there. I was literally convinced I was about to deliver. Then, when I was going through the written arguments of Justice Mr. Kayal, therein in one corner I found a reference to a case number, and that number was also wrong. Then I searched for it. I got it that this order neither parties placed before me. Just to give you the background, just examine that aspect of the matter.
Difficult. Deeply obliged.
15. Item number 15. 15.
Yes. Pass over matter. Item 5.
None appears for the petitioner even on second call. Accordingly, in view of the above, the writ petition stands dismissed.
Item 6.
Now we have the documents, which is referred in para 8. So there are 2 certificates and one it is 61. We will not go beyond this. What do you say?
Well, as per my instruction, one document has been submitted earlier, madam. That was misplaced by the office.
That is what now has come out. And there is same school, same signature, same everything.
Second, as per my instruction, the same certificate was placed before the.
How can you have the same certificate at different points of time with the same date?
Well, kindly look into one matter, madam.
Huh.
He has appointed in 1978, madam, an extra one, madam.
Hmm.
He's a driver, madam.
Hmm.
And in driving license, madam, date of birth is reflected, madam. If they produce the first initial, madam, driving license, then, madam, I have no.
That
case,
is
madam.
for you to produce. You have not produced that.
Well, as per
First appointment is of
78, madam. 87, sorry, 87, madam.
87.
17 August 1987.
So even if it is 61, you are above the age.
My lord.
Even if it is 61, you will be above the age.
If 61, my lord, if 68, my
No,
lord.
no, no, no. If it is 61,
My lord,
still you will be above 18 years.
my lord.
And if it is
68,
68,
then also I'm 18 years above, my lord.
68 also, you will be around 19 years.
My lord. But as per kindly next 2 month rare document, my lord. It is also reflected that my date of birth is 28 to 1968, my lord. Annex 2 month, page number 816.
And the driving license that you have brought on record
My lord.
is of 2016.
My lord.
You have also not brought the initial driving license on record.
No, all documents, my lord, is 1968, my lord, all including my medical, my lord.
Can't help it because
lord.
this statement in paragraph 8,
My lord.
you have also not countered by way of filing a affidavit. You have not filed a rejoinder to that.
My lord.
And very categorical statement. That's why we wanted to have further clarification. We asked him to produce. Now he has produced.
He said fixed pay, my lord, employee, my lord. No pensionary benefit, nothing, my lord, except, my lord, fixed pay. Only 2 years, my lord, is remaining, my lord. If they consider humanitarian, my lord.
You are still a fixed pay.
Well, it's fixed pay, my lord. Fixed pay, okay.
You have already retired, 61.
As per 61, my lord, I have.
Why he continued for such a long time as a fixed pay? And that too against the post of a driver? When did you retire? When did they make you retire?
21, my lord.
19.
21.
No, my lord, 2020, 28 to 2021, my lord.
Retirement is?
28 to 2021, my lord.
And the present writ petition was filed only in 23. Why it took 2 years to come here?
Well, before, kindly see the.
21, you filed a writ petition, you withdrew it.
My lord.
And then it took you another 2 years to.
And some earlier set up some dispute arises, my lord. He has filed when after his retirement. So some dispute arises between the.
Naturally.
My lord, page number 32, my lord. Order.
That is the absent.
33, my lord.
21 order.
My lord.
Sure, we'll have that.
And Annex 29, my lord. This is stated I am still at the time of my retirement fixed pay employee, my lord. My CL number 54, my lord.
What class you were studying, sir?
My lord.
6. So 6 would be 11 years. You left the school at the age of 13 years in class 6. In terms of both the certificates. In one it is 74, one it is 81. Therefore, I'm sorry, so good. Heard Mr. R. Hazarika, learned counsel for the petition. Also heard Mr. R. R. Gogoi, learned standing counsel.
Standing counsel, sir.
Agriculture
Number 4 and
Department.
5. 4 and 5.
Appearing for the respondents number 4. Standing counsel, Assam Agriculture University, appearing for the respondent number 4 and 5. And Miss G. Bora, learned standing counsel, Agriculture Department, appearing for the respondents number 1, 2, and 3. The challenge presented in the present petition by the petitioner is to an order dated 6/9/2019 and a notification dated 19/1/2019 issued by the registered Assam University. Rejecting the claim of the petitioner for a change of the date of birth recorded in his service records and further releasing the petitioner on attaining the age of superannuation from his services with effect from 28/2/2021. Also, the petitioner hearing was engaged as a driver against a newly created post in the Sugar Cane Research Station, Buralikon, Likison, under the Assam Agriculture University, Jorhat, while an order dated 17/8/1987 on fixed pay basis. Also, the petitioner continued to discharge his duties in the said capacity. Also, however, he was paid his remuneration on fixed pay basis. Also, a doubt having arisen with regard to the actual date of birth of the petitioner, the petitioner was wide communication dated 25/9/2018 issued by the register Assam Agriculture University. A doubt having arisen with regard to the date of birth of the petitioner herein, the petitioner was directed to submit documents. Also, further, the register Assam Agriculture University wide a communication dated 25/9/2018 required the District Elementary Education Officer Jorhat to verify a school transfer certificate produced by the petitioner, wherein he was denoted, wherein his date of birth was recorded as 28/2/1968. Also, the said issue had arisen on account of the fact that in the service records of the petitioner maintained by the university concerned, his date of birth was recorded as 28/2/1968. Also, in pursuance to the such process of inquiry made, the headmaster, Borbetta Public High School, Jorhat, had wide a communication dated 2/3/2019 informed the registrar, Assam Agriculture University, Jorhat, that the transfer certificate issued to the petitioner on 27/1/1992 by the then headmaster of the school and countersigned by the Block Elementary Education Officer was the correct reflection of the and the details set out therein was so set out basing on the records maintained in the office, maintained in the school. So thereafter, the register Assam Agriculture University, Jorhat, had wide communication dated 17/7/2019 required the petitioner to submit the original school certificate number 92/90-31 dated 21/92 for verifying his date of birth. Also, the petitioner responded to the said communication dated 17/7/2019, while his communication dated 24/7/2019, and therein contended that the original certificate obtained, original certificate of his, that the original copy of the transfer certificate was lost by him, and accordingly he submitted that he had obtained a duplicate certificate in the year 1992 from the school and submitted the said certificate, had submitted the said certificate to the authorities in the year 2016. Also, accordingly, he submitted that he is not in a position to submit the original certificate. Also, thereafter, the matter was taken up for consideration, and on such consideration, the registrar, Assam Agriculture University, while it is order dated 6/9/2019, proceeded to reject the claim of the petitioner for recording, for correcting his date of birth in his service records as 28/2/1968. The registrar in the said communication had noticed that as per the records, office records maintained, which also included a school leaving certificate dated 27/1/1992, issued by the headmaster, Gorbeta Public ME School, Jorhat, and countersigned by the block education officer, Jorhat. The date of the birth of the petitioner therein was recorded as 28/2/1968. It was further noticed that subsequently the petitioner had submitted a transfer certificate also of the same date, that is 27/1/1992 on 27/1/1992. However, herein his date of birth was changed as 28/2/1968. Also, the registrar further noticed that in both the said transfer certificates, in the said transfer certificates, both dated 27/1/92, the date of leaving of the school by the petitioner was not recorded, was not the same. So in one certificate, it was recorded as 22/3/1974, while in the other, that is in the duplicate copy, it was recorded as 22/3/1981. So accordingly, the prayer of the petitioner for having his date corrected as 28/2/1968 was cancelled. So thereafter, basing on the date of birth recorded in the service records of the university, the petitioner was, while order dated 19/1/2021, released from his services on reaching the age of superannuation with effect from 28/2/2021. Also, being aggrieved, the petitioner had instituted WPC number 1310/2021 before this court. However, the same was withdrawn, while was permitted to be withdrawn by this court, while order dated 1/3/2021 with liberty to file afresh. Also, thereafter, the present petition was filed by the petitioner on 8/2/2023, that is after lapse of around 2 years from the date of withdrawal of the earlier petition. Also, the facts as noticed herein above also gives, also, I have heard the learned counsel for the parties and also produced the materials available on the report. The contentions raised by the petitioner in the writ petition, when considered in the light of the affidavit, the contentions in the affidavit brought on record by the respondent university, as well as the submissions of the learned counsel for the parties, an issue has arisen as to the correct date of birth of the petitioner, as to whether the date of birth recorded in the service books of the petitioner as 28/2/1961 apostrophe D is the correct date of birth, and or 28/2/1968 as claimed by the petitioner is the correct date of birth. Also, it is the categorical submission of the respondent university, of the authorities of the respondent university, that the date of birth of the petitioner was recorded in his service book at the time of his entry into service as 28/2/1961. Also, however, the petitioner had, during the period of his service, disputed this said date and had contended his date of birth to be 28/2/1968. Also, the petitioner accordingly had furnished a transfer living certificate a duplicate copy of a transfer living certificate on 22/3/1974, and therein his date of birth was recorded as 28/2/1968. Also, the respondents in the present proceedings, in the affidavit, the respondents in the affidavit filed by them in the present proceedings has contended that the petitioner during the course of his service had submitted 2 school living certificates / transfer certificates, both dated 27/1/1992. So, in one of the said certificates, the date of birth of the petitioner is recorded as 28/2/1961, and the date of his leaving the school has been recorded as 22/3/1974, while in the second certificate, the date of birth of the petitioner was recorded as 28/2/1968, and the date of leaving his school was recorded as 22/3/1981. So, the said contention made by the respondents in the affidavit filed by them in the present proceedings has not been disputed by the petitioner by filing a rejoinder thereto. So, however, this court, to ascertain the veracity of the above contentions made in the writ petition, had required the Standing Council, Assam Agriculture University, to produce the copies of the school living certificates produced by the petitioner, to produce the school living certificate, school livings / transfer certificates furnished by the petitioners to the said university authorities for verification. So, accordingly, Mr. R.R. Gogoi has produced the 2 transfer / school living certificates today, today. So, on a perusal of the said certificates, the veracity of the contention made by the respondents in paragraph 8 of its affidavit stands affirmed. Full stop. It is to be noticed herein that the respondents have taken a categorical stand in the matter that the date of birth of the petitioner recorded in his service records maintained by them was so recorded as 28/2/1961. So, such assertion made by the respondents have not been denied by the respondents, by the petitioner, by bringing on record cogent materials. Also, the reliance placed by the petitioner in support of his claim with regard to his date of birth is reliance placed by the petitioner in support of his contention with regard to his date of birth is so placed on his driving license, PAN card, driving license, and a PAN card, in addition to the school living certificate dated 27/1/1992. So, the PAN card as well as the driving license of the petitioner produced on record was issued to him in the year 29/6/2016, and accordingly, although the date of birth of the petitioner therein is recorded as 28/2/1968, the same would be of no consequence inasmuch as such date of birth was recorded on the self-declaration of the petitioner. Further, in the PAN card, so produced, it is seen of the petitioner, so produced. So next to the petition, it is seen that the date of birth therein is also recorded as 28/2/1968. However, the same would also be not of any consequence inasmuch as the same is also based on a self-declaration made by the petitioner before the income tax authorities in the matter. Also, the reliance placed by the petitioner on the school living certificate dated 27/1/92, wherein his date of birth was recorded as 28/2/1968, and his date of leaving the school was recorded as 22/3/1981, would also not mandate acceptance in absence of an explanation from the petitioner as to how two certificates bearing the same date, two transfer oblique school certificates, school living certificate bearing the same date could have been furnished by him in the matter, and as to how the date of birth, that is 28/2/1961, was recorded by the school, by the authorities of the Assam Agriculture University in the service records of the petitioner. Full stop. It is in absence of an explanation being brought on record by the petitioner, it has to be presumed that it has to be held that the date of birth 28/2/1961, as recorded in the service books of the petitioner, was so recorded basing on the school certificate furnished by the petitioner in the matter. Full stop. In as much as there is no material brought on record to demonstrate that the date of birth of the petitioner in his service records was unilaterally recorded by the respondents without any reference to him. Full stop. In view of the above discussion, there being no material brought on record to counter the contentions raised by the respondents that the date of birth recorded by the petitioner in his service books was 28/2/1961, and the same also being in tune with one of the certificates furnished by the petitioner before the respondent. One of the school certificates, transfer of the school living certificate produced by the petitioner dated 27/1/92, this court is of the considered view that the order dated 6/9/2019 passed by the Registrar, Assam Agriculture University, as well as the order dated 19/1/2021 releasing the petitioner from his services on reaching the age of superannuation, would mandate any acceptance from this court. In view of the above, the present writ petition is held to be devoid of any merit, and accordingly the same stand dismissed. Sorry, unhelping. A statement should have been there countering this. The copies of the transfer transfer oblique school living certificate produced by Mr. R.R. Gogoi is kept on record and marked as ex poly for purpose of identification. Some explanation in your writ petition with regard to that order, that contention in the order. If it was there, we could have thought of something. Nothing, no pleading. Next slide.
Thank you, Your Lordship. Also, with
Yeah.
regard to item number 5, the matter has become infructuous, Your Lordship.
I have dismissed it for non-prosecution. Nothing is there. How can a writ be maintainable in this matter? Fight between a shareholder and the non-scheduled bank. It will लिखी दियोगे. Some नाम तो लिखी दियोगे. तो item number 5. अपनी solution ले. अपनी solution ले. Mr.
S. Gautam, Your Lordship.
Yes?
Gautam.
You're not there in the case.
Yes, Your Lordship.
Then forget it. We have dismissed it for default. I think that will be removed. Pleasure.
Item 7.
My lord, the petitioner is not here, but still, my lord, I would just like to place one judgment, my lord. The law has been settled in such cases, my lord. By Honorable Justice Shubhan Shyam, my lord. Similar case, my lord, whether my lord, a minor, my lord, after attaining the age, page number 3 from down below, B, it's there, my lord. Whether such cases is maintainable, my lord.
When was this application filed?
My lord,
5/5/2006.
no, 5/5/26, parent died, my lord.
No, what's
And
the application filed?
11/2/22. No, this is but the DLC meeting. She could not have, my lord, because she was only 6 years old when father died.
How can I get that?
My lord,
Next of kin, sir, huh? 11,
yes, my lord.
21.
Affidavit, my lord. My lord will find her age is 21 in 2023. Meaning thereby, if we go back to 2006, she was only 6 years old, my lord.
Yes.
So, my lord, cannot be. Law has been laid down, my lord, following a Supreme Court judgment. This is the law, my lord.
It is here, next of kin is here. 4 years. 2006, 4 years. None appears for the petition on call. Heard Mr. R. Learned Counsel, the additional senior government advocate appearing for the state response. Full stop. The petitioner, by way of instituting the present proceeding, has prayed for a direction upon the respondent authorities for the DLC had recommended her case.
No, my lord, DLC has not recommended. They said, my lord, I have a written instruction, my lord. They said that there was no vacancy. They could not recommend, my lord. They kept it in abeyance.
Okay, when was that meeting held?
My lord, 11/2/22, my lord. Here it is. 11/2/22, my lord.
Mr. Dhar, I don't understand one thing.
I know, my lord.
Compassionate appointment is compassionate appointment. There is a court order or no court order. How can they make a difference? Whether a court order will give it something more. It has to be by a comparative assessment always.
Exactly, my lord. My lord, this of it, my lord, even to educate this, my lord, individually, my lord, I call up these people, my lord, and try to make them understand, my lord, how to approach in such
My
a
only fear is that in future, near future, there should not be something like a scam of compassionate appointment. It should not be there.
my lord.
Because I'm not getting very good vibes seeing these briefs.
That is why, my lord, whenever such cases come, I
We were there till a year and a half ago. So we also know a bit of things.
My lord, my lord, my lord.
Only thing, my fear is that don't get to read in the newspaper that there is a big scam going on.
That is why, my lord, I'm just trying to assist the court, my lord, on law, my lord, whether this such.
Okay, we'll deal with it. Also, consideration of a case before the state level committee, SLC, for consideration of a case for appointment on compassionate grounds. Also, as projected in the petition, the mother of the petitioner, late Amina Begum, while serving as an auxiliary nurse and midwife, bracketed A&M, at Joy Krishnapur S/C under Lala PHC, Hailakandi, district Hailakandi, had died in harness on 5/5/2006. So the petitioner at the, now as projected now, as projected now, the mother of the petitioner, The next of kin certificate brought on record in the writ petition would go to show that in the year 2006, the petitioner was aged 4 years. Also, accordingly, the petitioner at the relevant point of time was not in a position to submit an application for appointment on compassionate grounds, and she had to wait till attaining the age of majority for submitting such application. Also, the materials brought on record would go to further reveal that such application was submitted by the petitioner in the year 2021 and or latest by the year 2022. Also, the application submitted by the petitioner was considered by the jurisdictional DLC district level committee in its meeting held on 11/2/2022 and thereafter in its extended sitting held on 16/3/2022. Also, on scrutiny, the case of the appellant was found to be eligible for appointment for appointment against any grade 4 post. However, on account of non-availability of vacancy for compassionate appointment in the establishment concerned, the case of the no recommendation came to be made in favor of the appellant for in favor of the petitioner for appointment on compassionate grounds for before the state level committee. Also, a perusal of the pleadings brought on record in the writ petition would go to reveal that the petitioner has not contended that her case was at any point of time after 16/3/2022 recommended by the jurisdictional district level committee for appointment on compassionate grounds. Accordingly, the prayer made in the present writ petition for placing the case of the petitioner before the state level committee for consideration of a case for appointment on compassionate grounds would not mandate and accept. Also, having noticed the above position, this court would also like to would further examine the eligibility of the petitioner for being extended with an appointment on compassionate grounds in the facts and circumstances involved in the matter. As noticed here in above, the petitioner's mother had died in harness on 5/5/2006, and at that relevant point of time, the petitioner was around 4 years of age. Accordingly, the petitioner the petitioner had submitted her application for appointment on compassionate grounds sometime in the year 2021. The long delay occasioning in the submission of the said application, would go to show that the petitioner had sustained after the death of her mother without being without any the long delay occasioning in the matter after the death of the father of the mother occasioning in the matter after the death of the mother of the petitioner. After the demise of the mother of the petitioner, without any of the family members of the petitioner being appointed on compassionate grounds, would go to show that the family had sustained the said period and the necessity of appointment on compassionate grounds at this distant point of time would not also be called for. Also, the present issue has been rendered stale. Also, Mr. Bhatt, learned counsel for the petitioner at this stage submits that as at this stage refers to a decision of the Supreme Court rendered in the case of so and so. Take any mind clear. A2. P2P mining. So according, in view of the above discussions, the present writ petition is held to be devoid of any merit and the same stands dismissed. However, there would be no other. No delay, they were brought to the town paragraph. Done. Dismiss.
Item number 11.
Yes,
If a lordship permits me to place the facts, I'll just.
facts we have.
2-3 minutes left. I joined the service on 1/9/1995 as an Arikati grade 4 postman. At that point of time, the next promotional post, the eligibility criteria was,
Yes,
eligibility criteria for the next promotional post was 5 years regular service and higher secondary pass when I was appointed, madam. This criteria was later on.
is there a rule?
Yes, ma'am.
What is that rule?
Madam, I have annexed that. It is at page 25, madam.
Okay,
Rule 10, madam. At page 31. Lower division assistant. Appointment shall be made by the appointing authority. I've come under 3, madam. By selection on the basis of suitability from amongst the grade 4 staff of the office who passed higher secondary or
now
equivalent
it's
exam.
graduation.
And this has been,
This is the directorate establishment.
madam.
Hmm.
So earlier it was 5 years.
So we accept your plea that you had the eligibility to be promoted as of, as when was your date of joining?
I joined in 1/9/1995,
So 5 years.
5 years. 2000.
So 2000, from 2000, you had the eligibility. No dispute on.
2016, my lord.
Huh.
The rule was changed. It was
Made graduation.
to graduation and 7 years of regular service. In 2018, after I waited for 23 years in the service, a selection committee was set up for making promotion. Now, what happens in that promotion? An ex-cadre employee is being promoted.
No dispute.
No dispute. My rights have been violated. there.
You came up before
I
this
come
court,
up before this honorable court.
interfered with.
This is interfered with.
So everything boils down to that order.
That order.
Let's
Now
see that order.
That order says at page 70, madam, the relevant portion. As the foregoing paragraph show, page 70, paragraph 12. As the foregoing paragraphs show that the present case is a covered matter wherein it has been held that persons who have been regularized against personal post cannot be promoted to a cadre post as they are holding ex-cadre post. The promotion of respondent number 3 is also not legally tenable. Accordingly, the promotion of the respondent number 3 to the post of junior assistant by the imperial order number 103 of so and so issued by the respondent number 2 is hereby set aside. So his promotion has been set aside. The state respondents are accordingly directed to consider the case of the petitioner for promotion of the post of junior assistant along with all other eligible candidates if the petitioner comes within the zone of consideration. Now my prayer before that earlier bench, the lordship will find at paragraph 3, madam, at page 63 of the same judgment. I'm relying on page 64, my lord, last 3 lines. The petitioner's counsel thus prays that the promotion.
So this is your prayer
This was my prayer.
and this is the direction.
This was the direction. His
So what
post
is
has been
this
removed.
direction? Is it for prospect? It is for retrospective or for prospective?
It doesn't say anything. madam.
It did not. Consideration
Because.
along with other similarly situated. Prospective.
My bad.
You file a review against that, that's all.
I can.
Otherwise, we cannot go
my
beyond
bad,
this.
I can do that.
You
Otherwise-
withdraw this, I'll give you
otherwise-
liberty.
my bad.
You withdraw this, I'll give you liberty.
Otherwise-
Mr. B. Prasad, learned counsel for the petitioner, after attempting to argue the matter at some length submits that the prayer of the petitioner for being granted a retrospective for a prayer of the petitioner for grant of retrospective effect to his promotion to the cadre of junior assistant effected while the order dated 15/6/2023 would not be possible given the direction contained in the order dated 6/5/2019 passed. Direction contained in the order dated 22/3/2022 passed by the coordinate bench of this court in the case in WPC number 6534/2019. Full stop. Accordingly, he submits that he may be permitted to withdraw the present writ petition with liberty to file an appropriate application seeking review of the said order dated 22/3/2022. Said order needs judgment and order dated 22/3/2022. Full stop. Prayer is not objected to by Ms. M.D. Bora, learned counsel appearing for the state respondents. Full stop. In view of the submissions made by in view of the submissions of the learned counsel for the petition, the present writ petition stands dismissed on withdrawal with liberty reserved to the petitioner to file appropriate application seeking a review of the judgment and order dated same passed by the learned Singh passed by the coordinate bench in so and so so and so. Otherwise, we can't help you.
Obliged, Lord.
And another point, if you had come out of this, the next question would have been, there are case laws. There are case laws in the case laws available that if the rules does not permit for a retrospective promotion, you cannot. You are in service still.
I'm still in service.
So the third question will not come. After retirement, how will you get it? So the first barrier, first barrier you get across, we'll see then.
At least if I can get this
That order line, if you can just get it reviewed, you get everything
if
there.
I get this, I can get.
Because you admittedly, we are with you. You were deprived for them, but can't help it because of that.
Obliged,
Obliged.
Lord.
No, 29th of April. I'm sure ekdam aram ho.
29.
Yes, madam. Anything?
Lordship, this part, I'll go by the OM Lordship there, that is the calculation part they have done. And another Lordship, these documents I have found here regarding same Lordship, the date of superannuation is corrected as per the admitted.
That correction will not hold.
Lordship.
When your date of birth cannot be changed.
Not, but my lord, as per the OM, that has been extended Lordship.
No, it cannot be. That is the mistake done. That is the mistake done. Can't help it. We cannot, madam.
Lordship will fix another date.
No. Today, you have done. There is nothing.
No, Lordship. Lordship may kindly.
Put number 1 now.
No, Lordship. Lordship may
what?
fix another date because Lordship, I will explain this part.
You, madam, that is why
No, Lordship.
I
page 9
was
is
waiting
stated.
for you.
Page, I have communicated Lordship there.
You
They
need
will-
not.
Tomorrow, Lordship.
Once-
Lordship,
once-
tomorrow, Lordship.
Today I fixed it because you were not there that day.
No, Lordship. Today is first time it came for.
No. I had heard this matter earlier.
No, Lordship.
No.
First time has come for hearing, Lordship.
Okay, fine. The night I read it, that's why the remembrance.
That is that Lordship Upenda's matter, Lordship.
No,
Lordship,
that was
fix
the-
another date. I'll satisfy your Lordship because on page 9 I have.
Madam,
stated
you
that-
just get over this page 27. I am with you. I am passing an order with you.
No, Lordship. I'll explain you.
Your
Lordship.
date of birth is
Lordship.
1/3/1963.
Lordship.
Any dispute on that?
No, Lordship.
Apply that OM.
Then
It
OM
will be 28/2 only.
It will be 28. No, Lordship. As per the OM, Lordship, there that has.
You
been
read it. Read
calculated.
the OM is before you, madam.
Lordship, the first paragraph that has been stated regarding the FR rule, Lordship, that is.
Forget
preceding
that. We are
month.
not in FR.
Then Lordship may find a calculation, if Lordship find the example
Huh.
of the age of a candidate. If we consider that, Lordship, I have explained in my page.
You
9,
are in page 28.
Lordship, page 28. That's
28. Okay, we'll examine that for you also.
Lordship.
Read that further.
Further, if the age of a candidate be mentioned in the old HSLC pass certificate admit card is 15 years, 10 months on 1st March 1999, his date of birth should be computed as 2nd May 1983. And the government servant shall retire in superannuation on 31st May 2043.
Okay, let us accept this for a minute. Now come to your matriculation certificate.
Lordship. That's
Page
page 30, Lordship.
30, huh?
Annexer C. That was on 1st March 1978. just
So you have a
15
pen?
years.
You have a pen?
Lordship, I have it.
Right. First 75 dash 03 dash 01. Huh?
Lordship, 1st March 1978.
8. Sorry. First write 78
Lordship.
dash 03 dash 01.
Lordship.
Now from 1978, what is the age given?
15 years, Lordship.
Deduct it.
Lordship.
How much do you get?
I'm unable to do.
78 minus 15 is
Lordship.
63.
Lordship.
Anything more required?
No, Lordship, that is correct, Lordship.
That your
No,
case
Lordship.
comes in, your case, madam, comes in the first example at page 27.
Lordship, now the OM that may not have been explained properly here, but by that OM,
That somebody has made a mistake, that will not
that
give
is
you a
not
right.
mistake, Lordship.
I am telling you, I am not proceeding to the part that you were given a pension after that, 1/4, not proceeding.
No, Lordship, that has been the OM that may not have been specifically stated here in this page. I may find it somewhere else, but Lordship, that has been corrected and number of employees, their age, that has been calculated and corrected. Because there were some anomalies.
Where is that? You should have brought it on record in the writ petition. You have not brought it. This writ petition was filed in 23, 2 years down the lane.
No, Lord, that was done immediately after his retirement. We had approved.
Madam, you have filed this writ petition
Lordship.
after the,
After
by
retirement-
taking into account all these factors. Where is that statement? That this is the OM that will be applicable.
Lordship, that was done by them. They have not stated anything
Then
regarding
need
the
not be.
OM.
We are now clarifying that.
But they
This
have
is the only OM available. 30. Is there any other OM? No.
But if Lordship takes up, I have another.
Where the petitioner show a document that he has approved the authority for correction of
Date of birth.
date of birth prior to my lord her his retirement. It's
Not
3 years.
date of birth is okay, Lordship. The date of retirement has been as per by.
Okay,
Lordship may fix another, not.
No.
per-
we have heard, we have invested much time.
Lordship may allow me to satisfy once, Lordship, tomorrow, Lordship.
The affidavit also, they have very categorical terms there.
But they have stated, Lordship, that the Deputy Director, Town and Country Planning was the appointing authority and controlling authority of the petitioner. Hence, all records are submitted in his concerned office and objection claim should be submitted in the office of the respond number 2 for rectification of any data. And also stated that no claims regarding date of retirement petition received from the concerned head of office or from the petitioner. Lordship, the petitioner may not have approached, but they have also not corrected, Lordship. That
My
is
lord,
also issue.
it is from 2012, he is aware, my lord.
Madam, change your date of birth, your date of retirement will also change.
Lordship may take them
Here-
another day. I'll satisfy your Lordship because Lordship, the things are to be taken from the first.
We have
Lordship.
wasted so much time.
Lordship, today humble prayer, Lordship may fix it another tomorrow, Lordship. Lordship, I humble request, Lordship.
Second, you know, by slip, we did Kalirati, first time,
Lordship. Much obliged, Lordship.
just for your satisfaction.
Lordship,
Done. Due.
much obliged.
My lord, again, fixing on 22nd, my lord,
Tomorrow,
or tomorrow.
Item 21 to 28.
Wait, please. My lord had heard this matter one point.
unfortunately, the note that I prepared,
I'll recapitulate.
and but where is Mr. Patwari?
My lord, he is appearing for 22 and 23.
One thing, we hear this matter today, it's not going to conclude. Again, there will be a, yeah, we were waiting for you. Because next week is a motion day. What to do? Tomorrow around 64, I can't accommodate. Immediately on reopening. I think I should not keep it parted any further. We don't know where we will be. We'll release it and
In any case, it is not parted.
Another bench.
Because it was parted. After your lordship, matter went to Honorable Justice Sham. There it was parted for some time. Then in the meantime, the intervening developments happened.
okay,
So now it has come up as a fresh matter before your lordship.
okay, okay. Okay, we'll have it then after vacations. We'll get it then. Oh, he released it only on 3/6.
That is after those intervening developments.
So it was heard twice, not released twice.
Oh, he had dealt with this matter for quite long.
That's right.
In fact, your lordship, I think, took it up sometime around February, March.
But thereafter, the March onwards, my Lord Justice Suman Shyam is considered.
Yes.
I think considerable hearing was done.
That's right.
Yes.
That's right.
On 2-3 occasions it was heard, but then
Okay, give me a date.
24.
Give me a hearing day.
24.
24 is a hearing day. Mr. Chaudhary, we don't want to take you to August. We'll finish it in because August you might have
24th time.
August you might have something there. You might have to remain there. As agreed, naam sobor likhi lo leho. Sabka len na. As agreed to by the Learned Council for the parties, registry to list these matters again on 24. Can it be 22?
22, I have another
Okay,
big
24.
matter fixed in the
24/7/2025 for hearing. Also,
Here, it's
Here-
already been ended.
it has been admitted.
Item 35 and 36.
Twenty-four, 24/7. 24/7, huh?
Made to you.
Mr. Ahmed, you are appearing in
36.
Jury Rani Savriya.
Yes.
And therein, Citrolekha Devi is a party respondent. She is a party respondent. Is there an interim order here?
My lord.
Yes, sir. Because of the
Interim order, you are not being, you are much afterwards. You are a much junior,
Junior to the.
but you are a graduate.
Right.
And you are appearing for?
Number 4, item number 30.
In item number 34. Right.
35.
Yes.
WTC 8602.
Okay. Okay. Yes, Mr. Sugya.
The petitioner was appointed, my lord, on 3/3/1997, 1987 as grade 4M.
3/3.
3/3/1987.
As a grade 4 employee
In my lord, under the establishment of this
in R3, District Deputy Registrar.
Yes. Thereafter, my lord, while vacancy was, my lord, arose in the cadre of my LDM, the petitioner applied for
Hmm.
consideration of her case to the post of the LDA in terms of the Rule 6.
When did the vacancy come?
My lord, it arose in 2010, my lord.
No, you say in 2002 itself you submitted.
My lord.
2005 you submitted.
My lord.
Then why did you come before this court?
My
There
lord,
were nobody senior to you.
my lord.
You were the senior most. All along.
No, my lord.
When did you come in the
My
zone?
lord, I became senior.
How many vacancies? 5. 5 into 4,
2005.
20. How many
2005.
grade 4 are there?
There are, my lord, only 4 persons are there.
Okay. This is by the district level ministerial act.
Yes.
10%.
My lord.
Huh?
My,
So what is the cadre strength of LDA?
my lord, 6 persons.
6.
6.
So 1 post.
1 4.
And any promoted person was working?
No.
Okay. Then?
Then, my lord, the petitioner, application of the petitioner was, my lord, forwarded.
Hmm.
Your lordship. There is page 15, my lord.
Hmm.
The 4 persons who are names were, my lord, forwarded, my lord.
Hmm.
The person placed at serial number 1 has already been retired, my lord.
Where is that forwarding?
Page 15, my lord, annex 3.
Hmm. Huh.
Thereafter, several communications are there, my lord.
Then DPC?
My lord. DPC was held in the year 2018, my lord.
So your first promotion grade 4, then there is a, what is that PSP?
Process server peon, my lord.
Process server. You were appointed on as process server
Yes.
on 31/3. Whereas the respondent number 4 was so appointed on
2000.
27/1.
Yes.
Okay. So as per the system followed materials here, grade 4, PSP, then,
My lord.
right?
PSP is not promoted post, my lord.
Then what is
It is a
it?
grade 4 post,
Okay, just an adjustment. Higher salary?
my lord.
Higher salary.
My lord.
Okay. Then, so all the peons are brought into PSP, then LDA,
Yes,
right?
my lord.
So LDA seniority, PSP seniority has to be noted.
My lord.
So in PSP, you are junior to the respondent number 4. And you have not said anything. They have made categorical statements to that effect in their affidavit.
Their only stand is that the rule has been amended, my lord.
Okay, fine. We'll come to that. When was the DPC held finally?
Your lordship will. Page 25, your lordship may kindly.
25. Okay.
Now, my lord, by MP on order, page 27. This is the, my lord, DPC, my lord. The petitioner, the respondent 4 has been appointed by order dated 19 February 2018, page 28.
28 is the
20 is
selection.
the DPC, my lord.
And 28.
8 is the MP on order.
Okay. So the DPC met sometime between what is this? This is a subsequent one, 4/6, page 27.
My lord.
He was promoted before that.
But the order, your lordship will find page 28, my lord.
No, 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 no. That is not the promotion order. What is the promotion order of the respondent number 4? You have filed an affidavit?
Page 20.
No, that is not the promotion order.
Then my lord, my repeating it. File my lord, just 53 my lord.
Huh?
Page 53.
50?
Page, and exactly my lord.
Ah. This is the order. Yes. This is not the order of promotion.
My lord.
Page 28 cannot be the order.
My lord.
That is just an approval. His case was placed thereafter before the selection committee and then he was promoted. Now tell me why this is bad.
My lord, the ground of the rejection of the petitioner's case is concerned, my lord.
Hmm.
Rule has been amended. The qualification of my lord high secondary pass has been increased to my lord graduate.
Hmm.
That is on the only ground. That amended rule is not applicable in the present case. As the law is well settled, my lord. Since the my lord post is vacant, was all vacant in the year 2005, my lord. When there is no amended.
Very not time. Okay, not applicable. Then where is your contention with regard to that?
In my additional affidavit.
No, no, in your writ petition.
Writ petition, there is no such my lord. In the in the
Additional affidavit?
Yes. There is there in the
When did you file that?
It was filed on my lord.
It's a reply affidavit.
My lord.
Huh?
My lord.
3/4/25.
Yes.
Okay, where?
Paragraph 9, my lord. The amendment rule is not applicable. Entitled to get promotion in terms of the earlier my lord rule that has been existed, my lord. And violating that, my lord,
Got it.
provisions of my lord, the
Got it. Got it.
respondent number 4 has been promoted. This is my case.
Page 32, paragraph 12. Page 32. 32.
In one similar case, but this honorable court has held by Justice S.K. Mehdi, my lord, that since the amendment rule is not applicable in that case, my lord, the relevant portion, my lord, page paragraph 14 onwards, my lord. 13 to my lord. 15.
To the post of LDA in 86. So the court said it cannot have a retrospective. To also bring within his fold the 86 promotion.
My lord.
Then how can it help you? How will it advance your case?
Kindly see the paragraph 6, my lord. The stand of the government then in the said case.
MD Bora.
My lord.
She has not said anything. She has not said anything.
She supported my, in that case, my lord.
She has not supported anybody. She said
Clarifies the stand, my lord.
you were the petitioner. Rather, she has the arguments made by the petitioner in that case. That is the same very arguments you are making. She objected. Para 5.
Rule 11 is
6, you can read 6.
my lord. Six B. By selection on the basis of seniority cum merit from amongst the grade 4 staff of the district establishment concerned, who have passed the higher secondary or equivalent examination, have rendered at least 7 years of service, 7 years of continuous service in the district establishment on the first day of the year in which the selection is made. In my case, my lord, the petitioner is entitled to post, my lord, after 1983-87. It will be, my lord, 1985, my lord. She was entitled for consideration to the post of promotional post in the year 1995, my lord. Post fell vacant, my lord, in 2005, my lord, when there is no, my lord, amendment rule, my lord. But in the year 2018, my lord, the respondent, in the guise of the amendment rule, my lord, my promotion has been rejected, my lord. That cannot be, my lord.
Your case is that
it is not that the post
the
fell
unamended
vacant, my lord.
rules have to be considered.
Yes, my lord.
Show me a judgment to the latest judgment on the Supreme Court on that point, or the High Court anyway.
My lord, the judgment I have placed before your lordship, my lord.
That will not help you. That will not help you because it is with regard to a promotion of appointment of 1986. Rightly said. But here, your promotion took place after the amendment.
Process is not started in the
Process
post
starting, that's why I'm saying, Mr. Saikia, other than saying, show me a decision.
my lord.
Rajkumar, what is the citation?
2023, 3 SCC 773.
I was looking for that only.
Yes. State of Himachal Pradesh and other.
2023.
3 SCC 773.
Rangaiah was done away with this in this case. Rangaiah laid down the point that vacancy The date the vacancy arises, the rule holding the field will be the criteria applied.
My lord.
That was done away with by Rajkumar. 30 years law done away with. That was the law which was holding for 30 years. Mr. Ahmed will know. Held the right to be considered for promotion occurs on the date of consideration of the eligible candidates, and the applicable rules would be the rules existing then. That is the rule in force.
My lord.
So, your DPC having been held after 2015, nothing survives.
It is the fault of the department, my lord. I have
You
nothing.
file a damages case. I can't help you. What made you wait? You should have come up.
Wait for employment.
Because your fundamental right was being violated.
My lord. She does not do it.
Right to consideration is a fundamental right.
That's true, my lord. But
Right
she
to
just
consideration for.
wait for employee, my lord, does not know the intricacies of law, my lord.
Yes. Yes, Mr. Ahmed, what is your grace? If we dismiss the first writ petition, your case is taken care of.
My respectful submission for Lordship and Your Lord. At that relevant time also earlier it was a higher secondary minor. And that time petitioner was matriculate only minor. That time also she was not fulfilled the required qualifications.
Which petition?
Earlier petitioner.
Oh.
Matriculate.
No, we know that. You stick to your thing.
My lord, the petitioner same manner she was appointed on 2011, my lord.
This petition.
This petition, my petitioner, my lord,
Hmm.
in Sahuria.
Hmm.
Then on being learned about the vacancy, my lord, she filed several representation. And
Hmm.
petitioner was a graduate at time of appointment, my lord. And as per list of PSP and norms of the seniority and requisite qualification, Assam District Ministerial Establishment Rule 1967, my lord, she is the most deserving candidate, my lord. Accordingly, my lord, subsequently, a selection board's meeting was held on 29/9/2021, my lord. That is page 47, kindly see, my lord. Sorry, page 40, Lord, page 40. It is a 4-member committee, my lord. Earlier, it was a 3-member committee, my lord. After objective analysis, all the vacancy post and qualification, my lord.
Page 40.
Page 40. Page 40, my lord.
40.
And
This is the
40, 9 September 2021. Much
committee.
later, my lord.
Committee.
My lord, committee, my lord.
Then.
And they, my lord, kindly come to the page 47, my lord. May I read out, my lord. In inviting the reference to the above, I have the honor to inform you that the Honorable Guwahati High Court, case number so and so, is supposed to be lying pending and be disposed of because of the undersigned is yet to be received any judgment by this or that way. In this connection, I would like to adhere that the DOE selection committee was constituted and committee proposed to fill up the reserved vacancy by way of promotion with Ms. Juliani Sahuria, my petitioner, my lord, PSP. That has been held up in pursuance of Honorable High Court's order, that is so and so, so and so. Because of this order, my lord.
Where is that order? 410.
Court order is, my lord. That is 42.
42 is 311.
Sorry, 43, Lord.
43 is 311. What is this 410?
Court stay order is, my lord, 43, my lord.
There is no stay order there. It's just a subject to outcome.
Sorry.
Process, this is the case, my lord.
Because of the disorder, my lord.
This is pending before this honorable court. There is no such interim order though, but this matter is pending for so department don't want to. Go for
Because of the disorder, my lord, I was.
The matter would consider.
So if we dispose of the first writ petition, your thing gets settled.
My lord, some observation rejection. Otherwise, my lord, several.
We'll direct that
My lord,
we'll take up this letter 47. Say that now the case is settled. They'll proceed in accordance with law.
My lord, maybe retro effect, my lord. 5 years I am waiting, my lord. 5 years, non-fault of mine, my lord. I mean, graduate, my lord. Last 5 years I am waiting because of this wrong interpretation of the disorder, my lord. Department.
Can't help it.
So my humble prayer before Lordship, my lord. Issue was forwarded, considered, my lord, on October 22, my lord.
There was no order from this court. You should have Press that. You have not pressed that. You filed this writ petition in 24.
No, my lord, since in their committee, they themselves, my lord, forwarded my name on 14 October 22, my lord, after objective analysis of the all criteria as required by the law, my lord, rule, my lord. So, my lord, may be giving effect on from that day, my lord. This is my humble prayer, your lordship.
Anything more?
Nothing.
Yes. Anything you say?
It's my favor, my lord.
You think the court will be in your favor? This is all tentative view.
Lordship.
That upon lordship, as per authority admitted, fairly admitted that my position, my lord, that
No?
she is eligible in page 57, my lord.
How they dare not admit it fairly when Mr. Ahmed is there?
Lordship. 57, 58, my lord, they fairly submitted
Heard
that
Mr. P.J. Soikia,
because of the disorder, my lord, my promotion. Yeah.
also heard Mr. M.U. Ahmed, learned for the petitioner in WPC number 8602/2018. Also heard Mr. M.U. Ahmed, learned counsel appearing for the petitioner in WPC number 2297/2024. Also, also heard Mr. A.U. Ahmed, A.K. Ahmed, A.K. Azhar,
My lord.
learned counsel appearing, also heard Ms.
MD Bora.
MD Bora, learned standing counsel, Corporation Department,
1, 2, and 3, my lord.
appearing for the state respondents in the above noted two writ petitions, and also Mr. A.K. Azhar, learned counsel appearing for the respondent number 4 in WPC number 8602/2018. Also, the issue raised in the above noted two writ petition pertain to the claim of the claim made by the petitioners in the above noted two writ petitions pertains to their promotion to the cadre of junior assistant in the establishment of the district deputy registrar cooperative societies Dorong, Mungalri. Full stop. ऊपर में एक लिखा देना, as agreed to by the learned council for the parties, the present petitions are taken up for final consideration and disposal. WPC number 8602/2000. Also, the petitioner in the present proceeding was initially recruited as a regular grade 4 staff on 3/3/1987 in the establishment of the Deputy Registrar Property Societies Dorong, Nolri. Also, the petitioner thereafter has been rendering her services in the said capacity till date. Also, the petitioner at the time of her recruitment had the qualification of matriculation. Matriculation. Full stop. Although vacancies had arisen in the next higher post of lower division assistant bracketed now junior division assistant, comma, as far back as the year 2002, comma, no recruitment process was initiated for filling up the post in question. Also, the petitioner, having acquired the requisite eligibility criteria for being promoted to the post of junior assistant, comma, submitted a representation in the matter in the year on, submitted a representative matter on 2010. Also, thereafter, it is contended that the matter was processed and a proposal was submitted for filling up of the vacant posts of LDA LDA available in the office of the respondent number 3 or deputy registrar General Likana, bracketed respondent number 3 here in detail. That is the respondent number 3 here. Also, The petitioner projects that after her appointment as a grade 4 staff, she was accommodated as a, what is that, process?
PSP.
Process server peon.
As a process server peon with effect from 31/3/2006. So, the respondent authorities had published a gradation list of process server peons and peons on serving in the establishment of the respondent number 3 as on 30/11/2010 and circulated the same via a communication dated 6/12/2010. In the said gradation list of PSP, the name of the petition figures hearing, petitioner hearing figures. Also, the petitioner contends that that after the vacancies had arisen in the cadre of junior assistant, the petitioner contends that the recruitment to the cadre of LDA existing in the establishment of the respondent number 3 is governed by the provisions of the Assam Ministerial District Establishment Service Rules 1967. So, Rule 6B deals with the promotion of grade 4 employees to the post of LDA. So, the petitioner submits that he had acquired the eligibility criteria for recruitment to the cadre of LDA and had the prescribed educational qualification that had held the field during the period the vacancies in question had so arisen. The learned counsel for the petitioner has further submitted that during the processing of the matter for consideration of the cases of the eligible grade 4 staff for promotion to the post of LDA, the provisions of Rule 6B came to be amended in the year 2015, and the educational qualification was enhanced to that of graduation. Also, the petitioner further projects that by reckoning the amended qualifications, the respondent authorities proceeded to hold a selection, and the respondent number 4 herein, having the degree qualification, came to be promoted to the post of junior assistant while issuance of an order dated 18/6/2018. Also, being agreed, the petitioner has instituted the present proceeding. MUM. Some facts, if I leave down, just tell me. Mr. WPC 2297/2020. Also, the petitioner, as projected in the petition, the petitioner was appointed as a process server peon while order dated 14/2/2011 and was posted in the office of the Registered Cooperative Societies, Assam. Also, thereafter, the petitioner was transferred and posted to the office of the District Registered Cooperative Societies, Torong, that is the respondent number 3 hearing. 3 hearing, and she has been continuously discharging her duties in such capacity.
She district deputy registrar.
District deputy registrar. Also, the petitioner projects that at the time of her recruitment as a grade 4 employee, as a process server peon, bracketed PSP, the petitioner had already acquired her graduation qualification. So, the petitioner having served for a period of 7 years and having qualified and having acquired the eligibility for being considered for promotion to the next higher grade of junior assistant, comma, she also being a degree holder, comma, approached the respondent authorities for consideration of a case for promotion to the rank of, to the cadre of junior assistant. So, the application submitted by the petition was processed and the respondent authorities wide order dated 9/2/2021 constituted a selection committee for filling up of one post of junior assistant by way of promotion from grade 4 staff. So, the petitioner contends that in the zone of consideration for the said post identified for being filled up from amongst the incumbents in the eligible incumbents in the cadre of, in the grade 4 cadre of this, of the set of the establishment of the respondent number 3, comma, it is only the petitioner hearing who has the degree qualification and had also completed the requisite numbers of years of service in grade 4. Also, however, in view of the order dated 3/11/2021 passed by this court in I bracketed C oblique 1823/2021 bracket में in WPC number 8602/2018 instituted by the respondent number 4 hearing and the petitioner in WPC number 8602/2018, wherein the court had observed that any appointment made to the post of junior assistant by the selection committee constituted by the order dated 9/9/2021 would be subject to the outcome of the said petition, comma, the respondent authorities have kept the selection process in abeyance, thereby prejudicially affecting the service interest of the petition. Also, being aggrieved, the petitioner has approached this court by way of instituting the present writ petition. Anything fact let out, Mr. Amit? Mr. Soike, any facts let out? Nothing?
Only the page 47 may be considered, my lord. Other things are not disputed, my lord.
That we will bring it in your submission and then we will take over. This is the fact.
Yes.
This is the.
Disposed of.
Lord, obliged.
We'll give a time frame within that you consider. Both
Just we kindly record the application judgment that I have printed.
Rajkumar, we'll do that.